indulgence.
Not the mentioning.
My lord, there is extreme urgency in the
Mention
matter.
on Monday. What is urgency?
The urgency is the recruitment process will end on 9th, my lord, and the candidate.
Mention on Monday. Sorry,
My lord,
Constable GD, I know.
yes,
Mention
my lord.
Monday.
My lord, kindly fixes it on Monday.
No, sorry,
my lord.
mention on Monday. Yes, other matters are also running in the list.
My lord, 9th it is ending, my lord.
Yes, yes, yes.
My lord, also I have a very urgent matter because I have retired in the year of 2018, and since
Why you are mentioning today? 18 retirement. Mention on Monday.
Maybe I'm permitted to mention my item number 21 of common list, my lord. Due to my personal inconvenience, I will have leave Kolkata, my lord. I am
21 of monthly list.
monthly list of 21, my lord.
So you
Not
tell
today.
anybody to pray for time. I will accommodate.
my lord, it is also my
Matters who have been, my lord, liberty has been granted to file separately, and writ petition has been affirmed that since it is 9th, my lord, may it be taken up Monday, my lord.
Mention on Monday.
Lord,
Mention on Monday. Let me see.
Lordship, I crave to mention a matter.
If I file it, they will not. After filing, mention, my lord. May I
Yes,
mention
after filing you mention, give the presentation form and date. It will come as per presentation form.
date unless the 9th would be the date, and 9th is the last day of medical. Otherwise, I would not insist, my lord.
Another lady advocate mentioned this matter. Same 9th. I have refused her prayer.
my lord. This is running in the monthly list, my lord. It is at the hearing list.
You file today, indicate that matter to be listed on Monday. It will come. If other side appears, I will tell. Otherwise,
They will not accept the filing.
Tuesday.
Tuesday,
Yes.
Tuesday is the 9th.
Yes. And mention on Monday, then I will apply.
But another thing, that is last occasion the order has been passed, my lord. That is the was measured in the review, was measured 169.6, which is less than 70 centimeter. In place of 170, it will be corrected on the next day.
170?
In place of 170, it has been typographical error is 70 only. On the
Next date you indicate?
Lordship, I crave to mention a matter.
Today is not the mentioning date. Mention on Monday. Unless until you cannot wait till Monday.
My lord, my matter is running in the monthly list, your lordship.
Mention on Monday. Today is not the mentioning date. Those matters I am entertaining because 9th is the date, last date for medical examination.
Yes, yes. No.
Item number 1.
Just a minute. সোমবারে শোনো যে ম্যাটার গুলো ওই 9th এর আসছে না কনস্টেবল জিডি 9th Yes, market value.
Yes, ma'am.
This is the report. দিলাম তো আজকে দিলাম তো সেকেন্ড ডিসেম্বর আজকে দিলাম তো এক্ষুনি দিলাম তোমাদের Yes, indicate from the report. The
My
market
lord.
value.
যেটা দাওনি এইটাই দিলে তো তুমি এইটা তো দিলে
হ্যাঁ।
মার্কেট ভ্যালু
Give a copy to them, otherwise how they will accept
No, no.
the proposal. Yes,
If you want to, my lord, kindly come to the first page,
first page,
my lord.
there is a table,
My lord, there is a table and the total 168 decimals is 60 lakhs
168 decimal, 60 lakh 70,303.
in aggregate.
That is, the entire area is 168 decimal.
Only 168.
My lord, 160.
There is a mistake, my lord. More 17 decimal will be added.
Yes,
More
No, my lord,
17 decimal land will be added.
Wait,
There is some mistake.
where this mistake occurred? Tell me where this mistake occurred.
But they said, my lord, in their earlier report,
এই ইয়েগুলো দাও, এটা তো শুধু অর্ডার শিটটা।
1.75.
No, 1.68.
এই তো তুমি কি দিয়েছো?
Total.
Did not receive the position back to 1.75.
1.7 নয়, তোমাকে তো 1.68 দেওয়া হচ্ছে টোটাল। টোটাল জমি
আমার তো যা বাকি ছিল তাতে তুমি বলেছো 87% দেওয়া হয়েছে 1.8
সিপিএনটা কোথায়?
11:39 থেকে তোমাকে দেওয়া হচ্ছে কত?
13-14 থেকে তুমি 11-39 দিয়েছো। তো বাইরে তুমি বলেছো এখানে 1.75
না,
এই তো
হ্যাঁ,
হিসেব
ওইটা
করে
CPN
দেখুন।
এই দেখিস ওই দেখো না আমি
লিখে
হিসেব করে দেখি
কেন দিচ্ছ
ঠিকই তো
কেন?
আছে।
ফার্স্ট পাতাটা
ঠিক
দাও,
আছে।
ওটা লাগবে না, আমার এরকম ভাবে পাল্টাতে ছিঁড়ে যাবে পুরোনো রেকর্ড।
No, 1.68.
দেখো বার করো
ওয়ান পয়েন্ট সিক্স এইটই তো সবসময় লেখা
না,
আছে।
না, না, তুমি এই তো লিখেছো তোমারই তো এটা কাগজ এটা ডিস্ট্রিক্ট ল্যান্ড অ্যান্ড রেভিনিউ অফিসারের কাগজ দেখো
কবেকার ওটা?
রিপোর্ট অফ দ্য তুমি তো রিপোর্ট দিয়েছো
কবে দিয়েছিলাম?
তারিখ ফারিখ কিছুই তো নিয়ে গেছে
1.68 এই তো সবসময় 1.68।
শিডিউলটা শুধু যোগ করে এটা বলছে ওখানে 700 decimal আছে। এরকম করে সব-
সাবস্টিটিউশন যখন সব এলাও হয়েছে 1.68 দেয়ার ইজ নো
তোমার এই রিপোর্টটা কোথায়
কোনটা?
এই যেটা দিয়েছো এটাই যে রিপোর্টটা কেন কেন একসঙ্গে
কখন কি রিপোর্টে? ওটা অনেক পুরনো 19 এই দেখুন এই তো সবসময় 1.68 and you have never disputed about 1.65 68।
দামটা দেখেছো
কত বলছে
ঠিক আছে ওটা নয় বাদ দিলাম দামটা কি দেখো
সরকারি value।
বলতে হবে চেক আপ করে আমরা
এটা আমাদের কাছে সরকারি।
তাতে কি রিপোর্ট ডিস্টেন্স ডিফার করছে কি ডিফার করেছে দেখো যেটা দিলো সেটা দেখো
State to the state. Stance of the state. Vision of the social state.
কোটি ছিলাম
আপনি তো কথা ভাই
সাপ্লিমেন্ট রেডি করতে গেছে।
তো সব রিপোর্টেই তো 1.68 আছে
তাহলে
এবং আপনি কোনোদিন ডিসপিউটও করেননি
না,
1.68।
না, আমার তো তোমাদের আমার তো এটাই পাও না
না 1.68
একবার তুমি ভাগ করে বলে দিয়েছে ভাগ করে বলে দিও
তো কে বলেছে? আমি তো শুনতে পাচ্ছি না।
এটা ডিএলএর
তো ওটা ছাড়ুন
অ্যাডিশনাল ডিস্ট্রিক্ট ডিএলএর বলছে
কবে বলেছে?
কি তারিখ দাম
নো আপনার কন্টেম্পট এডিশনাল ডিস্ট্রিক্ট ম্যাজিস্ট্রেট যে রিপোর্ট দিচ্ছে সেটাই।
এই তো শেয়ার নম্বর কন্টেম্প কিন্তু দিচ্ছে
ডেট নেই।
ডেট নেই এটা তো ডেট
না এগুলো সব রয়েছে বুকে। এগুলো সব
Yes,
my lord, valuation which given my lord is not tally one with the current market price, my lord.
well, this is from the sub register office report.
what should be the valuation you tell this court?
Lord, we have taken a assessment from online That is,
Now, with regard to area of the land, it is settled.
My lord, adjacent land, my lord, we can return back them their adjacent land, the earlier report we have submitted. Or the market, they pay the market value, we are ready to pay the market value.
Accept this valuation
no, my lord.
and then raise a dispute.
Yes.
Raise a
except-
dispute.
We shall file a supplement.
I will grant you leave. No, I will dispose it off.
My lord.
Enough is enough. I will direct the
Even if-
authorities.
My lord, may I submit, my lord, even their quantum of land is, my lord, is different.
No, I have seen the order.
168. Or is
I
it-
have seen the order. Please
Oh,
come to
in
the
all
order
the
passed by
orders-
Justice N.K. Mitra as his lordship then was.
No, but I am not saying
68,
that, but
1.6.
according their report, my lord,
Please come to the order passed by Justice Mitra as his lordship then was. Page 36 of the writ petition. Because the discussion which was going on amongst the learned advocates, it struck my mind that
Yes.
there may be a dispute with regard to the area of the land. Come to the order passed by the coordinate bench.
my lord, then, my lord, after checking, my lord, I'll give a one date next time.
4th October 1996 order.
96
Yes.
order.
Yes, there nowhere it is stated that the area of the land is a land in question. So in contempt jurisdiction, court will not decide this.
My lord, in contempt matter.
Now I will accept this money.
Yes.
Let this payment be made. I will grant you leave to raise dispute regarding present market value of the
My
land.
lord.
That you can pursue the remedy.
You can supplementary evidence.
But I will not dispose it up today because
My lord.
Yes.
the payment will not be made.
Yes.
Again, another round of contempt will start.
Yes, my lord. After
So
payment,
within which period, Mr. Mahato, your client will be, contemptor will be able to make payment.
within 3 weeks, my lord, we will make payment.
Very well, within 3 weeks. 60,70,303. Total
My
amount.
lord.
ওটা আমরা নেব না।
নেবে না।
My lord, we shall not accept that amount, my lord.
Yes.
We have taken an assessment from online that is differ for heaven and hell, my lord.
Yes.
Even and
My lord,
valuation.
Our from this assessment report, our quantity or amount is 2,23 lakh.
So give a statement in that event. Very well.
And we need to file the supplementary affidavit with.
No. By this, in a similar way, you
Similar nature,
submit.
one
No,
similar
supplementary
nature
affidavit.
of land, not
You
not the
indicate that how
homestead
this
or
quantification is,
not the homestead or
how this quantification is made. You indicate.
Yes.
You are disputing this price. Now you demonstrate that how this quantification is made.
Yes. My lord, this is the classification of the
Then I
land.
can direct Mr. The alleged contemptor that on what basis this
Yes.
this amount. So, Mr. Mahato, that when they have agreed to accept the price,
Yes.
let a quietus be put to this issue.
My lord.
Otherwise, you have to return the land,
Yes.
demolishing the
Yeah.
everything on there. But that is the order passed by the coordinate bench.
My lord. My lord,
Be serious on this issue
my
and don't bargain with regard to the
No,
price of the land.
my lord,
What is the present price you have to pay?
Yes.
my lord, present price, my lord, the classification of the lands, I have given the plots number. If your lordship kindly see in Pukur part, what is the current rate?
Where from you are getting Pukur part?
Yes.
My lord, kindly see the, my lord, third column.
Third column.
But
Yes.
this decimal rate,
Then Suna.
Then Suna. These are the classification of the land in the record of rights.
What is that nature of land? Suna?
Suna, that is the agricultural land.
Agricultural land.
My lord.
Then Pukur part and agricultural land, they are saying, Mr. Mabdar, they are saying that this is 60,70,000, 17,303. You are disputing it.
Yes.
You demonstrate that this
That-
should not be this is the value.
This is
which
not the market
this is not
value
the
as per
correct value.
register.
What is the correct value?
Yes.
Demonstrate.
Demonstrate.
Today, are you in a position?
I have taken the report from the valuation from the registration office, but not government
What
re-
classification
government
of
report.
land?
See, Mr. Mahato, see it. What is the classification?
Classification of land, Sally.
Sali.
and in the
It is Suna. No, Suna. Not the same
Both
classification.
are agricultural land. Sally and Suna both are
Maybe,
agricultural.
but
my lord,
the government rate. It is not my rate.
Building has been constructed, already nature has been changed. All land are Bastu land. No Suna, no Sali.
And my land is all one Bastu land, my lord.
My lord, please.
In the roadside, your lordship, can you see the picture, my lord? Your lord, see the valuable land, my lord.
এটা 20,000 টাকা মার্কেট ভ্যালু বলছে এটা
20 lakh।
ক্লাসিফিকেশন
20 lakh.
এটা কি ল্যান্ড
existing market value.
না না এক্সিস্টিং মার্কেট ভ্যালু
All land are
Classification
Bastu land.
কোথায় কোথায়
Zero
কোথায়
দিয়ে-
ক্লাসিফিকেশনটা
Already they
কোথায়
are building 35.
What would be the market rate based on the rate fixed by the registration office?
registration office
That has to be paid.
my lord I have given the rate from the registration office
So you show me that for Suna land at the area, at the said locality, what is the market value based on which you are denying this quantification of price?
my lord
Show me. Then I will direct accordingly to the
Yes,
alleged
yes.
contemner to enhance the amount.
enhance my lord my lord we are not bargaining my lord we are my lord in the
Court is ready to accept if you can demonstrate that in the same area of land, same classification, what is the present market rate as per the rate fixed by the registration office?
কোথায় কি ক্লাসিফিকেশন আছে
At present, all land are Bastu land. They are
all land বাস্তু land
already nature has been changed.
No, that who will consider it? Court is not going to consider
my lord the
it in
record
respect
price
of Suna. What is the present market value?
present market value
Tell me.
পুকুর পাড় what is the present market value
Moja is one
Nature,
deeper, my lord.
nature has been already changed.
same মোজা
Nature already changed, my
Then, my
lord.
lord, we have to check, my lord, whether the Moja is one.
Who is the appropriate registrar or sub-registrar of the area? I will direct him to demarcate the land and make a valuation and submit a report.
Yes, my lord.
My lord, in the year 2023.
my lord ADSR Pandua my lord
DSR Pandua.
Pandua
Yes, my lord.
I will take valuation directly from ADSR
yes
Pandua.
yes my lord
Additional district sub-registrar.
additional district sub register Pandua
Then I am recording your submission that if price is appropriately fixed considering the present market rate of the land in question, in that event applicants are ready to accept the same.
my lord
And now it is to be found out that what would be the market price of the land
Well.
in question. Mr. Mahato, use your good office.
my lord
Don't bargain with the petitioner.
Lord,
They are
I am not
fighting this
bargaining, my
case
lord.
from 1996.
my lord
And we know that these government officers always fix the price at a lower rate,
my lord
at the lower level, always in land matters. So therefore, use your good office,
my lord
enhance the amount in terms of the current market rate,
my lord
and the let the matter be let a quietus be put to this issue.
my lord
Matter issue. Matter is taken up for consideration in presence of the learned advocates representing the applicants and alleged contemners. Stop. Next paragraph. Learned advocate representing the applicants submits.
ADSR Pandua yes
ADSR for the
my lord may I have kindly my lord
Yes. Yes.
Dunia
কি বলছেন learned advocate representing the applicant submits that applicants are willing to accept price of the land if quantification of the valuation of the land is made appropriately, taking note of the area of the land in question and the current market value of the said land.
From such moja.
Stop.
Yeah,
Contiguous moja.
Next paragraph. Mr. Mahata, Mr. Lolit Mohan Mahata, learned additional government pleader, has submitted memo dated 2nd December 2025 issued by the additional district magistrate and district land and land reforms officer Hooghly, enclosing document showing the area of the land in question is 168 decimal in total, or total area of the land in question is 168 decimal, and the price of the said land is fixed at rupees 17,303. Stop. Quantification of next paragraph. Quantification of valuation of land in question is disputed by the learned advocate representing the applicant, and it is submitted if appropriate area of the land considering its location is taken into account. In that event, based on current market value, total price of the said land would be much higher. Next paragraph. Having considered the respective submissions made on behalf of the parties, court finds fit to get valuation of the land in question from additional district sub-register Pandua. ADSR Pandua. Hooghly or Pandua?
Pandua district. Pandua.
So ADSR additional district sub-register
Pandua.
Pandua. কি বলছিলাম? Fit to get a statement of valuation of land in question from additional district sub-register Pandua, Hooghly. Stop. Leave is granted to the learned advocate representing the applicants to add additional district sub-register Pandua, Hooghly as additional respondent by amending the cost title of this contempt application in course of this day. Stop. However, service of notice upon the additional respondent stands dispensed with, since Mr. Lolit Mohan Mahato, learned additional government pleader, is representing other respondents. Stop. Next paragraph. The learned advocate representing alleged contemners, the learned advocate representing alleged contemners is directed to obtain statement of valuation of the land in question, considering the location of the land and considering location and nature of the land based on present market price. সেন্টেন্সটা কি বললাম? না, from the additional respondent by 3 weeks from date. Now by 24th December 2025, and file the same on the next date. List the matter under the same heading for further consideration on 9th January 2025.
My
2026.
lord, I want to file a 10 application claiming compensation.
Nothing else. Now, no further.
It is already filed by not by you.
No further application. Sorry.
The matter is already filed by your lordship. Can you check at the time of hearing?
No, I will not entertain any other application. Let me consider this issue first.
Okay, I'm getting it to find.
No further leave is granted.
I'll get it.
Item number 2.
In some matters, parties including advocates do not want to conclude it.
Affidavit of compliance.
The matter is whether the wrong time is pending. madam.
Yes,
Might not give lordship.
that is the main difficulty.
And they will.
In one matter, I was appearing before the Honorable Chief Justice, Honorable Division Bench presided over by the then Chief Justice, and this matter was continuing for a long period of
Yes,
time.
my lord.
Public interest litigation.
the-
Then there was a change of determination and a new bench came. On the said date, matter was disposed of. On the first date, matter was disposed of. Get the permit the applicants to see the color of money. Long drawn procedure, they have made a proposal which is found to be feasible so far this court is concerned. So therefore, let the matter let the price be paid to the petitioners. Otherwise, they will never get any relief.
Also, we are also trying.
Yes.
to settle the matter.
You are the advocate. Also try to pursue the applicants, considering the present situation. Yes, please. Next matter.
Item number 2.
For the petition.
Uttarpara Kutlong Municipality, we have filed the affidavit.
Affidavit of compliance.
Is filed.
Where is the order?
Page 12. my lord.
Who is shouting? Who is shouting? Go outside and shout.
Page 12. my lord.
Go outside.
Original report valuation. I'm sorry, my original valuation report, but which is handed over. Return back.
Yes. Where is the order?
Order.
218 proceedings was initiated and an order was passed. Where is the order?
Annexed R4, dated below
Page
17,
12.
page 12, dated 17/11/2025.
Construction was not shown. Sit here. Where is the decision of the Board of Councillors?
Lord, decision of the Board of Council will appear.
Page 10.
1 minute, my lord. Yes, my lord. Page 10. And hearing was given in the page 9 and 8. 9 and 8. 8 and 9. Hearing was given.
And annexure R2 page 7 is the my lord, notice for hearing.
Now, if this is a notice, if this is a notice dated 8 November 2025, within 48 hours, petitioners are asked to appear before the board of councillors.
Yes, my lord, they appeared on page 8, my lord. Hearing was
Why 7 days notice was not given? Yes. 8 of November 2025 notice fixing date of hearing on 10th of November 2025.
Yes, my lord, they appeared.
9th, 10. Why 7 days notice was not given?
I'm sorry, my lord, but in the instant.
And where is the decision of the board of councillors?
Yes, my lord, page
Page 10.
page 10.
পৌরসভার 37 বাজার লেন উত্তরপাড়া ওয়ার্ড নম্বর 16 যাতে জোতের বেআইনি নির্মাণের বিষয়টি আলোচনার জন্য বোর্ডের সভায় পেশ করা হলো। আলোচনান্তে পৌরসভা 37 বাজার লেন জোতের বেআইনি নির্মাণের অংশ ভেঙে ফেলার সিদ্ধান্ত বোর্ডের সভায় অনুমোদিত হলো। Can it be a decision under section 218 of the West Bengal Municipal Act 1993? Is it the part of section 18, 218?
Lord, it is a fact.
Whatever may be the fact, Mr.
Inquiry was
Mukherjee,
done. Inquiry was done. R1.
it has to be appropriately dealt with while passing an order.
Elaborate.
Lord, elaborate.
How you can substantiate this order? Show me section 218.
My lord, annexure
Take it
R1.
out.
Annexure R1.
This cannot be an
Inquiry.
order.
Annexure
A cryptic order, nothing, no reason, nothing is there.
My lord, inquiry report is page 6, my lord.
Lord, para 2. Picture R1. Fact remains that there is no plan in respect of this 400 square meter.
R1 6.
Just a minute. See section 280.
Board of Councillor have the power.
See section 218. এই দাও তো ওনাকে। Board of Councillors shall pass an
Yes.
order after giving opportunity of hearing.
Entire proceedings while initiated by the chairman.
I know that I have limitation in contempt jurisdiction. But court directed that under section 218 a proceeding is to be initiated and is to be and such proceeding is to be brought to a logical conclusion. Now an appropriate chance of hearing, that is not 48 hours notice, at least 7 days notice, and the very well petitioner is represented, pass a reasoned order. I am not on demolition whether it is rightly decided or wrongly. That is your prerogative in terms of the statutory provisions.
But I admit there is some lapses.
Yes,
There is some lapses, but I
there is some.
tendered apology.
No.
I tendered apology for that. In the
Therefore, I am granting you 4 weeks time. Initiate a fresh proceeding, give them opportunity of hearing, adequate opportunity of hearing, and Board of Councillors shall pass a reasoned order.
My lord, one thing is that, my lord.
And file a fresh affidavit of compliance after some time that I will indicate in my letter.
My lord, one indulgence, my lord. My lord, there was an inquiry by the SAE.
Yes, that
Yes, that's
report is
R1.
there.
And there is a found that some deviation is there, my lord.
So you take notice of that deviation
Yes.
and see the order of the Board of Councillors. In the order, there is no reflection that
Reflection
the
of the-
order of sub-assistant engineer has been taken note of.
Yes, my lord.
Nothing is there.
But in the annexure, I have annexed the same, my lord.
Nothing is there. It is there. I have seen that there is an adverse report by the sub-assistant engineer which goes against construction. So court is not restraining you to pass an appropriate order based on the report submitted by the sub-assistant engineer on inspection,
My lord.
but pass an elaborate order.
My lord, my lord.
ইস, দাও তো বইটা।
তো টাইমও শেষ হয়ে গেছে 17 তারিখের অর্ডার 2 সপ্তাহ টাইম
কি করে দেয় সেটা? কি করে বুঝিয়ে দেবো? order দিলে পরে করতে পারবে?
আমার ডেভিয়েশন আছে
In terms of,
I want one thing.
yes,
My order, blood, in this Board of Council, given notice, demolish the building within certain period. So what will be, that will be stopped. If this is followed, Lord, then there's no.
yes, a new order is to be passed. This order does not
Fresh
remain.
order to be.
Fresh order is to be passed by drawing up appropriate proceeding.
See,
Since court directed to initiate proceedings under 218, this is not a proceeding under section 218.
chairman has no authority board of councillor has the authority
In terms of the order dated 21st November 2025, affidavit of compliance is filed, which was affirmed, filed on behalf of alleged contemners, which was affirmed on 2nd December 2025. Next paragraph. Though it is contended on behalf of the alleged contemners by Mr. Deepak Kumar Mukherjee, learned advocate, that on concluding proceeding under section 218 of the West Bengal Municipal Act 1993, an order was passed by the Board of Councillors on 13 November 2025 but on perusal of document at page 10 of the page 10 of affidavit of compliance is it does not appear that Board of Councillors passed order on appropriately concluding proceeding under section 218 of the said Act of 1993, ওপরে 1990 said Act of 1993, said Act of 1993. Furthermore, it appears that a notice dated 8 November 2025 was issued to the parties to the said proceeding, fixing date of hearing on 10th November 2025. Thereby, not even 48 hours notice was given. Thereby, it transpires that not even 48 hours notice was given. Stop. However, it is submitted that parties appeared before the Board of Councillors. Next paragraph. By order dated 15 June 2023, alleged contemners were directed to initiate proceeding under section 218 of the said Act of 1993, and there was further direction to bring the said proceeding into logical conclusion by 16 weeks therefrom action. Stop. Steps were taken by the alleged contemners hurriedly, as a result whereof order was passed on 13 November 2025, which by no stretch of imagination can be termed as a reasoned order on concluding proceeding under section 218 of the said Act of 1993. Where is the report of the SAE?
Page 6, my lord, annexed R1.
That is also 8th November.
A report dated 8 November 2025 was stop. It is next paragraph. It is submitted on behalf of alleged contemners that a report dated 8 November 2025 was considered, and based on such report, order of demolition was passed, comma, but in the said report, but in the order of the Board of Councillors dated 13 November 2025, there is no indication that such report dated 8 November 2025, but there is no indication that said report was relied upon. Next paragraph.
The first paragraph of that report, Lord. His majority, after perusing the report of the sub-assistant engineer, that concerned that fresh construction was made at the top floor of the building number 37 by 10 Bazaar Lane.
Notice.
That is the communication of the chairman, but in the order dated 13 November 2025, nothing is there. Next paragraph. In view of aforesaid anomalies as found to be present in the proceeding initiated under section 218 of the said Act of 1993, it cannot be construed, it cannot be concluded that the order of this court dated 15 June 2023 is complied with by passing order is complied with by the concerned authority of the municipality by passing order / resolution dated 13 November 2025. Stop. Next paragraph. Alleged contemners are directed to initiate appropriate proceeding under section 218 of the said Act of 1993 after granting opportunity of hearing to the parties to the said proceeding within a period of 4 weeks from date. Stop. 4 weeks from date and pass a reasoned order. Stop. Alleged contemners are directed to file affidavit of further affidavit of compliance by 2 weeks thereafter. Stop. List the matter under the same heading for further consideration on 1, 2, 3, 4, 6. On 30th January 2026. Take it back.
That
Item number 337 for monthly list.
Lordship, this is my application, Lordship.
You have served notice of
Lordship.
it has returned back.
Yes, Lordship. Track report is there that he has received. This is the first affidavit, sir. Lordship.
Then why is another
That-
envelope
that
was
is-
sent?
Earlier direction was to send it to the CMOH. We have sent it. One CMOH has received and one has come back, Lordship.
One has?
Came back, Lordship, with the direction left, Lordship.
No, but the court directed to serve notice upon the additional alleged contempt.
That has been done, Lordship. First affidavit service, Lordship. Track report delivered, Lordship.
November. 12 Krishna. 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 Then serve notice about the learned advocate who represented the state respondents.
Lordship, the writ petition.
This you are alleging order violation of the order dated 29th August 2022. So Mr. Nilotpal Chatterjee and Amritlal Chatterjee appeared. I'll permit you grant you leave to serve notice upon Mr. Nilotpal Chatterjee.
Lordship, I shall.
Issue. Affidavit of service filed today is taken on record. Stop. In spite of service of notice upon the additional alleged contemner, who is the present district magistrate of Paschim Medinipur. Comma. Alleged contemner is not represented. Next one. Client advocate for the applicant is directed to serve notice upon Mr. Nilotpal Chatterjee, learned advocate, who represented the state respondents before the coordinate bench at the time of writ petition was disposed of.
Lordship, writ petition disposed of.
At the time of disposal of the writ petition, being WPA 18158 of 2022 within bracket Suthopa Ghosh versus the state of West Bengal and others. Stop. Let such notice be served upon the learned advocate by 7 days from date. By 7 days from date. Stop. List the matter under the same heading for further consideration in the monthly combined list of January 2024.
On fair, Lordship. Along with Nilotpal Chatterjee, Lordship, I shall serve.
2026, eh?
I shall serve to Nilotpal Chatterjee, Lordship. I don't know whether he is still in state panel or not, Lordship. Along with that, Lordship, I shall serve a copy to the GP also, Lordship, government breeder.
It will be, but in 1 or 2 matters he appeared before.
I don't know. Once I have heard that he was.
একটা line add করে দাও. Leave is also granted to the learned advocate representing the applicant to serve notice enclosing copy of the contempt application and copy of this order upon the learned government pleader
Much obliged.
by 7 days
Lordship,
from date,
Lordship, I shall.
and file affidavit of service on the next.
On
Next.
Item number 338.
Item number 338, I beg to appear for the alleged contempt. I am being led by my senior, Mr. Suman Basu. He's on his legs before courtroom number 90. I am playing for a short pass, or he's coming. He's just.
Well, Passover, come back.
Just
Praying for Passover.
yes.
Item number 339.
For the punishment option, read by Mr. Peter Sun, paying for.
Contempt, no further time. Last occasion also accommodation was paid for. Repeatedly, this cannot be allowed.
Akshay, will kindly make it a short pass over.
No, all matters cannot be made. Last occasion I prayed, I allowed time. Yes, where is the contempt?
That the school authority ought to disburse. My lord, in writ petition, I was the private respondent number 6. And my lord, last occasion when the matter was taken up, my lord queries is that whether any appeal is pending or not. On that day, my lord, appeal was pending. My lord, on 9/11/2025, appeal is dismissed. My lord, I only have my lord soft copy, my lord.
Appeal preferred against this was dismissed.
Yes, your lordship.
But no steps regarding payment of
Yes.
pensionary benefits.
No.
No liability certificate was not issued.
Not issued till date.
এই এই অর্ডারটা একটু বার করে নেবেন। Met 1681 of 2024, 19 November 2025. 2025. করে ওনাকে দিয়ে দেন। এসো। Learned advocate representing the applicant, learned advocate representing the applicant alleges violation of the judgment and order dated 23rd August 2024. So it is also brought on record. It is also brought on record to Kedera. It is also submitted that appeal was preferred against state judgment and order dated 23rd August 2024, being MAT so-and-so of 2024, and same was dismissed by the Honorable Division Bench, video order dated so-and-so. Next part. Right advocate representing the applicant is directed to serve notice upon the alleged containers single alleged container, including copy of the contempt application and order passed today by fortnight from date, and file affidavit of service on the next date. List the matter, next paragraph, list the matter under the same heading for further consideration in the monthly combined list of January 2026. Stop. Next paragraph, hereby it is made clear that pendency of this contempt proceeding shall not preclude the alleged contemner to comply with the judgment and order dated 23rd August 2024. এটা Met 1681 of 2024 and order dated 19 November 2025. Next.
Item number 340.
For the petition. Your Lordship's order is at page 18.
Page
18, Lordship. There was a demolition work, there was a debris due to the demolition work, page 19, concluding portion.
What is it? Here's the demolition. Since the population is the person since accommodation of this
Page 21 is the communication.
So the debris have not
Yes,
been removed.
page 26 are the photographs I have annexed, Lordship. Kindly see. This is the situation.
Issue. Learned advocate representing the
Corporation.
Applicants alleges violation of the order dated 4th March 2024 passed on the writ petition, passed on the connected writ petition. Stop. Next paragraph, learned advocate for the applicants is directed to serve notice upon the alleged contender enclosing copy of the contempt application and the order passed today by fortnight from date and file affidavit of service on the next day. List the matter under the same heading for further consideration in the monthly combined list of January 2026. Stop. Next paragraph. However, it is made clear pendency of contempt proceedings shall not preclude the alleged contender to comply with the order dated 4th March 2024.
Grateful.
Next.
Item number 341.
My lord, may I pray pass over, my lord?
Why?
That my lord, file which were handed over, my lord, it is wrong file, my lord. My clerk is bringing the file, my lord. Short pass over 5
You
minutes.
don't have the record.
Yes, your lordship, file I don't have, my lord. Short pass over may be given, my lord. File is, my lord, handed over a wrong file, my lord.
Passover.
Yes.
Passover গুলো এখানে রেখে দাও। Next.
Item number 342.
Lord, I am for the petition.
I am for the alleged container, my lord, it has been complied with. My lord, it given it.
ড্রাফট করা হবে দাও না আমার তো কমপ্লেন্স দিতে হয়
During course of hearing, learned advocate issue. During course of hearing, it is order dated 13th February 2025. During course of hearing, learned advocate representing the parties have jointly submitted that the order passed by this court on 13th February 2025 is complied with. Stop. Next paragraph. In view of such submission made on behalf of the parties, contempt application is disposed of and contempt proceedings stands dropped. Urgent xerox certificate for me. Have you filed affidavit of service? No.
Earlier occasion I have filed.
My lord, the report, compliance report may be taken on.
ও ওইটাই আমি জিজ্ঞেস করছি দেখি ওই ডিসপোজালের লাইনটার আগে একটা লাইন অ্যাড করে দাও অ্যাফিডেভিট অফ কমপ্লায়েন্স ফাইল
সব বলে দেবো
হ্যাঁ তাই করো অ্যাফিডেভিট অফ কমপ্লায়েন্স ফাইল অন বিহাফ অফ দ্য alleged contemner affirmed on
In December 2025.
2nd December 2025 is taken on record.
Item number 343.
I am for the petitioner. Page 32. My lord was please to
First time.
first time. 12th March 2025.
Interim order.
Interim order.
Admissible retail dues was allowed.
dues allowed, page 36. But the lordship will.
Page 34 of the order.
34 last.
So it was paid, admissible retail dues was paid. Yes, then
Last page, last paragraph.
page 36,
34,
34 yes.
last paragraph.
Shall not exist on no excess drawn amount, no refund of alleged excess drawn amount. Yes.
So page 36, they have deducted the amount. Serial number, the middle portion, deduction due to salary overdrawn.
Within the table. Yes, where is it's a nomination? Just a minute prior to that. How much amount was deducted?
10,06,872. And gratuity paid only 95,527 after deducting that amount.
TI has been is the and DBBG. Yes. Learned advocate representing the applicant alleges violation of the order dated 12 March 2025 passed by 12 March 2025 passed on connected writ petition. Stop. Learned advocate for the applicant is directed to serve notice enclosing copy of the contempt application and the order passed today by fortnight from date and file affidavit of service on the next day. Next paragraph lists the matter under the same heading in the monthly combined list of January 2026. Next paragraph, however, it is made clear, pendency of contempt proceedings shall not preclude the alleged contemners. More than one contemners? Yes. Shall not preclude the alleged contemners from complying with the order passed by this, from complying with the order dated 12 March 2025. 12 March 2025. Next. Serve notice, come back.
Item number 344.
This is also exactly same.
Same.
Page 25.
I am appearing on behalf of the state.
In contempt petition, unless and until you are engaged, you are difficult. Let the notice be served. Thereafter, if you are engaged, then appear before this court.
Page 25. This is the same, the page 26 at the top.
Just a minute. Previously, there was a fixed advocate who used to appear in contempt matters on behalf of the state respondents. Now this system is not there, perhaps. Pension paid, but alleged excess drawn amount has been withdrawn, has been deducted.
Deducted. Page 29. $1,97,462. Issue. Client advocate representing the applicant alleges violation of the order dated 20 May 2025 passed on connected writ petition. Next paragraph. Learned advocate for the petitioner, learned advocate for the applicant is directed to serve notice enclosing copy of the contempt application and the order passed today upon the alleged contemners by fortnight from date and file affidavit of service on the next date. list the matter under the same heading for further consideration in the monthly combined list of January 2026. Next paragraph. It is made clear that pendency of this contempt proceeding shall not preclude the petitioner to comply with the order dated 20th May 2025.
Item number 345.
Who is appearing for the applicant? You are appearing for the applicant?
No, I'm the respondent. I'm the respondent.
Chairman, West Bengal Central School Service Commission.
No, no, no.
You are making mistakes.
Oh, 345. Oh, sorry.
Here the chairman is.
No, I'm not there.
Because I never find that you appear for the commission.
345.
At the time of call, no one appears for the applicant and no accommodation is paid for. Next paragraph. In order to grant one more chance to the applicant, hearing of this contempt application stands adjourned. List the matter under the same heading for further consideration in the monthly combined list of January 2026. Next.
Item number 346.
About you have one. There is certainly this.
But possibly, Your Lordship.
That is from 1st April to 15th February. Yes.
Lord, I am for the alleged contempt. The order has been complied with, my lord.
Have you granted interest on Provident Fund for the
Yes,
period from 1st of April
Yes,
2022 to 15th February 2023?
The check has been prepared, my lord. He was called upon, my lord. My lord, he did not turn up. Letter was issued to him. It was received, and my lord, the check is with me in my hand, my lord. If my learned friend takes it.
Before that, but kindly see the order dated 26 November 24. This order was passed in 26 November 24 in presence of the learned advocate representing the school authorities. Now, when I might communicate the order, now might kindly see page 33. But on 28 February 2025, this alleged contemptor, teacher in charge, is writing me, first paragraph, hard line from bottom. But the order has not been communicated officially to the authority of such and such till today. Without due communication of the said order, I am unable to comply the order. I have communicated your lordship's order, I can show. Now, thereafter, what happened? Thereafter, they intimated me, but kindly see the last page, that we are unable to pay the amount. And that is at page 60. I'm sorry, not 60, before that page.
Now they are ready, they are coming with a check.
Kindly visualize when a headmaster is moving pillar to post initially for filing writ petition. Thereafter, November order was passed. Thereafter, again they did not comply. when they are they have issued the check
May I tell
kindly
your lordship
after
candidly?
receiving the contempt application.
May I tell your lordship
That I
candidly?
know.
I have gone.
What can be done? No, you accept the check, whether the check has been issued
Yes,
in the name of the petitioner.
it is in the name of the petitioner. At my instruction, it was done, my lord. It was communicated to him since.
Show
he
me
did-
the check.
Yes.
Give a copy, take a copy, print out of this check.
And my lord, this communication, my lord, it was.
It's wholly on interest.
Yes.
The total client.
Lord, kindly see the forwarding letter.
But when this was been sent, my lord, kindly see. I have this copy.
Yes, because my lord,
Yes, after
and
initiation
my lord, I
of
had, my lord,
contempt proceedings.
as an officer of the court, I tried my lord best my
হ্যাঁ?
lord, to comply.
তার
with
আগে
it.
লিখে দিলি যে করুন।
Because my lord, this is my lord, the erstwhile, my lord, I did not, my lord, justify my lord in other ways, but my lord,
Payment of due.
Kindly see the date. Initially, they said you have not communicated the order. Then we will not grant. Then contempt. Who will pay the? If I put this question to myself, who will pay the cost of this contempt, my lord? এই তো এসে গেছে পরে।
1st of December letter.
lordship,
7 November this.
I tell you lordship, my lord, when the contemners came to me, my lord,
একটা কপি রেখে দাও।
yes,
আমি অর্ডারটা
he had a misconception.
ওকে হাতে দিয়ে দেব।
Only thing kindly visualize who will pay the cost of this contempt.
The present TIC had a
At least
serious.
10 rupees cost, my lord. Kindly visualize the situation. At least 10 rupees token cost.
My lord, but may I
Otherwise,
tell-
these people will never. Your lordship has a vast experience. I should not say anything because I was never in that. This side.
Matter is heard in terms of the order dated 7 November 2025 in presence of the learned advocates representing the applicant and alleged contemnants. Next paragraph. Learned advocate representing the alleged contemnants submits that a check being number 089352 dated 25th November 2025 drawn on Indian Bank is issued in favor of the petitioner, in favor of the applicant for payment of interest on provident fund for the period from 1st of April 2022 to 15th February 2023. Top. Copy of the check is placed before this court and same is taken on record. State check dated 25th November 2025 is made over to Mr. Devjit Mukherjee, learned advocate, representing the applicant for onward transmission, representing the applicant. Stop. Stop. Next paragraph. In view of issuance of check dated 25th November 2025 in favor of the applicant and same is made over to the learned advocate representing the applicant, court finds that the order dated 26th November 2024 is complied with. Next paragraph. Hence, contempt application stands disposed of and contempt proceeding stands dropped. Urgent xerox certificate. এই ওটা ওকে দিয়ে দাও, এটা কপি করে affidavit service you have filed today. ওপরে দিয়ে দাও affidavit service filed on behalf of the applicant is taken on record.
Deeply obliged, my lord.
Sorry.
No cost.
My
So
lord,
for this matter.
deeply obliged, my lord.
Original check টা আমায় দিয়ে দেবে না?
হ্যাঁ ডাকুন।
Passover matter item number 338.
Passover item number 338. Other side is present.
Milord, Mr. Basu Milord came. Now Milord, he was outside. Complaint করেছে। Now Milord, this order was made in December 2023 to Milord, directing the page 22 is the order. Second paragraph.
কোনটা দিই?
দিইনি।
Yes, decision has been taken
My lord,
on a revalidation of
my lord,
the sanction
the
plan.
hearing started, my lord, hearing started, my lord, the then commissioner was transferred, then the new commissioner has already heard the matter on 17th November 2025, my lord, and order has been, will be committed today itself, my lord.
Milord, after your lordship, Milord,
14 November order was passed.
yes, thereafter, Milord, they
Yes,
fixed
that's
a
right.
date for hearing.
My lord,
Will appear get an order in terms of this.
appeared
I
to
have
the hearing.
appeared.
Appeared. My
So
lord,
I am adjourning the matter within which time you are within 7 days.
by this week, my lord, order will be communicated.
Yes. Affidavit service today you are filing.
Yes.
Affidavit service filed on behalf of the applicant is taken on record. Next paragraph. Learned advocate representing
Chandanagar Corporation. Chandanagar Municipal Corporation.
representing alleged contemner submits that steps have already been taken to comply with the order dated 18 December 2023 passed on connected writ petition. Stop. Next paragraph. In order to enable the alleged contemner to comply the order dated 18 December 2023, hearing of this contempt application stands adjourned for stands adjourned. Stop. Stands adjourned. Stop. Next paragraph. List the matter under the same heading for further consideration in the monthly combined list of January 2026. Stop. Alleged contemner is directed to file affidavit of compliance on the next date.
Grateful.
Affidavit service টা করে দিয়ে দিও। Another Passover matter.
Item number
341.
341.
The petition. My lord, kindly come to my lord, page number 16, order impugned, my lord.
First time.
First time, my lord, and relevant is, my lord, ordering portion is page number
Page 60.
16, 16.
16.
My lord, relevant is 23.
This is in connection with which selection process?
First SLST regarding work education. my lord. This matter is not set aside by the apex court. my lord.
Yes, yes.
This selection process.
Upper primary? No.
Yes, my lord.
Upper primary work education. Now you are not called for counseling.
Not call for any counseling process. Not call for any counseling process. my lord.
Issue. Learned advocate representing the applicant alleges violation of the order dated 4th September 2024 passed on connected writ petition. Stop. Next paragraph, learned advocate representing the applicant is directed to serve notice upon alleged contemners, enclosing copy of the contempt application and order passed today by fortnight from date and file affidavit of service on the next date. List the matter under the same heading for further consideration in the combined monthly list of January 2026.
Item number 347.
I am for the applicant, my lord. My lord, in the month of
346 মানে dispose of হয়ে গেল না? 347. Yes, 347.
My lord, in the month of November, the contemner complied the lordship's order, my lord. Released all the amount, including interest, in favor of the petitioner.
It was heard last on 7th November. Thereafter, order has been complied with.
Yes, my lord. No, my lord, I have not served any contempt application.
It is ordered dated 7th March
Yes, my
2025.
lord.
Issue. Learned advocate representing the applicant. You are representing the applicant.
Yes,
Learned advocate representing the applicant on instruction submits that the order passed or submits that order dated 7th March 2025 passed on connected writ petition is complied with. Next paragraph. However, alleged contemner
Respondent number 2 and
however, alleged contemners are not represented. Next paragraph. In view of aforesaid submission made on behalf of the applicant, contempt application stands disposed of and contempt proceeding stands dropped. Urgent Xerox certificate copy.
Great.
Item number 348.
Yeah, my lord, I have alleged contempt of your lordship's order. Your lordship, remember your lordship passed an order.
Just a minute.
Yes.
During course of hearing, it is taken into consideration for subject. Telling with some of the cases of
Yes. How it is contempt?
Yes.
Already a list of tainted candidates was published.
My lord, may I, my lord, after your lordship's order was passed that no tainted candidates will be allowed to participate. My lord, it was carried over an appeal before the division bench by the state and the commission. And my lord, the division bench upheld your lordship order, not even modified, simply upheld your lordship's order first. Thereafter, my lord, Supreme Court was also in season of the matter that tainted candidates, whether tainted candidates were allowed. The Supreme Court said you publish the list of tainted candidates. My lord, pursuant to that, they purportedly published a list of tainted candidates. My lord, thereafter, the matter again went before the Supreme Court, and the Supreme Court passed an order, my lord. This is the very latest order saying that High Court should ensure that no tainted candidates slips through and no tainted candidates participate. My lord, may I place this order, my lord?
Yes.
Page number 8, my lord.
Just a minute, let me get my lord.
Yes.
Yes, my lord. From my lord, your lordship's order first has been upheld by the division bench. Division bench in addition, my lord, if your lordship kindly comes to page 72 once of my application.
Yes, page 72.
My lord, 72, I am pushing paragraph 32 at the bottom, my lord. Paragraph 363, Roman 4 has classified three categories of candidates who can be described as tainted candidates. Person who have been tainted outside the first. Can you describe this?
Persons who have been tainted.
Who have been tainted outside the panel. My lord, second, persons tainted after expiry of the panel. Persons who have submitted blank weighman sheets to obtain appointments. So, my lord, division bench has clarified these are the three categories of tainted candidates. My lord, the purported list which they have published, my lord, only contained Weimar issue and out of panel, not after expiry of panel, my lord.
But Mr. Dasgupta, you appeared before this court when court considers batch of writ petitions challenging the list. Now, I dismiss those writ petitions upholding the list which was published in terms of the order of the Honorable Supreme Court. Perhaps that was a list dated 30th October 2025.
List or advertisement?
No, list of tainted candidates.
List, no list was published, my lord. This 18th, I did not appear, my lord. Mr. Lahiri appeared challenging that list of 18-6. My lord, your lordship,
No, the list of tainted
candidates was published.
And I upheld the list.
Yes. And that
Since this list was published in terms of the order of the Supreme Court.
My lord, I have
And other reasons were given.
Yes.
Against which appeal was prepared, appellate court did not interfere with my order.
And the Supreme Court also did not interfere, my lord.
Now, after that exercise,
Yes, my lord.
what remains?
Yes, my lord. What was the challenge in that, my lord? I can produce the writ petition also and the order. Some tainted candidates went before your lordship, came before your lordship and said that kindly see, my name ought not to have been there. Your lordship correctly upheld that list. It's not that that list is bad. I am not challenging that list. That list is not exhaustive. Your lordship's order was no tainted candidate should be allowed. If they have published a list containing a number of candidates, but there are B, C, D candidates.
Yes, you are correct to certain extent, because in those matters, which I dismiss those matters, they were the some of the tainted candidates who challenged the
list, my lord. Your lordship kindly
who challenged the list.
Who challenged, and your lordship rightly upheld, because that
and I refused their prayer to exclude names of those petitioners.
Yes, my lord.
From the list of
from the list of that candidate. And I am not challenging. I am saying that list
that some more candidates
tainted candidates are there. Specifically, I have mentioned expiry of panel, my lord, is not been included. Admittedly, my lord. Admittedly.
But if my order was modified to certain extent,
no, it is not modified, my lord, by the division.
By the honorable division bench, then the contempt application
my lord, it is not even modified. Kindly see,
because doctrine of merger will apply.
My lord, only thing there is, your lordship is also aware, my lord, there is a larger bench judgment of our lordship. If it is upheld, my lord, presently I don't carry the larger bench. Your lordship knows, if it is upheld, then my lord, contempt will lie before your lordship. And why
you have drawn notice of this court
in paragraph 35, 32. These are observations. These are not modifying your lordship's order.
Where is the concluding part of the judgment?
Yes, my lord, page 77. Simply dismissal of both the appeals, not even a modification or nothing.
It'll sub notice. Let me hear commission.
Yes, madam. My lord, only thing I would like to request your lordship knows 31st December. My lord, can it be do it a little faster? Because if they get appointment again a chaotic situation.
Appropriate order can be passed in that day.
My lord, only thing though it is not recorded, my lord, the order I have placed before the Supreme Court, my lord, I appeared, it was brought to the notice of the court that this is pending. That is, my lord, specific. The Supreme Court said the High Court should take into this.
That is the purport of this
Yes,
order.
and
passed by
I
the Honorable
specifically mentioned responsibility. I mentioned, my lord, I was there.
Because the
that-
Honorable Supreme Court has said in this order that only objective of the Supreme Court in connection with those
To
matters
see
was
that
to
no
see
tainted
that the
candidate.
order of judgment of the Honorable Supreme Court passed in Boisakhi Bhattacharya Supra is to be complied with.
It's to be complied with.
But other issues are raised which are pending before the, and in connection therewith matters are pending before the Honorable pending before the High Court. So let those issues be decided. Uninfluenced by the observations made by the Honorable Supreme Court in those writ petitions concerning which relates to
Other
the,
issues.
observations made in Boisakhi Bhattacharya. Learned advocate representing the applicants alleges violation of the judgment and order dated 7 July 2025 passed on a batch of writ petitions. First one being WPA 12505 of 2025 within bracket Sanjay Kumar Doloi page 26. Sanjay Kumar Doloi and another versus the state of West Bengal and others. Next paragraph. Learned advocate for the applicants is directed to serve notice including copy of the contempt application and order passed today upon the alleged contemners by fortnight from date and file affidavit of service on the next date. Stop. List the matter under the same heading in the monthly combined list of January 2026.
Deeply wrong.
Item number 349.
As per your lordship's direction, I have served the copy of the contempt application upon the alleged contemptor. This is my affidavit of service. Now kindly see your lordship's order. Order dated 1st July 2025. Now, paragraph 10 and 11 in page 19, this is important.
Yes.
Now, next page, page 21. The headmaster immediately issued the letter to the DI, while subject forwarding of the application for rejoining and release of the salary. Now, next page, my lord, page 23. I also made an application before the administrator also. Nothing response from the DI or administrator.
What response you expect from DI? Because court has set aside the termination order
I am
issued by
entitled
the
to
DI.
join. I am entitled to join. They are not allowing me to join.
Who is not allowing?
Hello?
Who is not allowing you to join?
Administrator, teacher in charge. Now, after the contempt application was served, suddenly DI issued this letter. Kindly see. And administrator also issued the letter after the contempt application was served.
Problem is nobody is appearing today. Have you whether
No, thereafter,
is the only alleged yes, thereafter
on 2nd December, I am allowed to join.
very well. Now, what remains?
21st November 2020.
Now, what remains?
I am telling you. DI have already
now you are working
from right, but 5 months lapsed. They did not take any steps from July to November. Now, my lord, DI has also told the administrator, you allow him to join, but I will not release the salary. I will not release the salary. No, only I am praying, my lord, since my lord, I have joined in the November 2025. Now, my lord, let the DI be directed to release the salary. Other they will release the salary.
But the question, the time has not come to release.
No, wait, the time will come. They will release the salary.
Will come. Time is not over. Time will come. Let us see whether the payment is made or not. 1st of July. Now the Madrasa authorities made contempt.
No, Madrasa authorities.
Who administrator is made contempt. Who appeared for the administrator?
Nobody is appearing.
Now, at the time of disposal of the writ petition?
Nobody is appearing.
Yes, at the time nobody appeared.
5 months have already been elapsed. Since
in spite of where is your affidavit? In spite an affidavit service filed on behalf of the applicant is taken on record. Stop. Next part. In spite of service of notice, alleged contemners are not represented today. Next part. Client advocate for the petitioner is directed to serve notice upon Miss MS Topoti Samanto, learned advocate who represented the state respondents at the time of disposal of the writ petition. Writ petition being WPA 10714 of 2025 within bracket Sheikh Mustaq Ali versus the state of West Bengal and others, close bracket. Stop. সেন্টেন্সটা কি বললাম বলো তো, টাইম বলা হলো না। না না আপনি পুরোটা বলবেন by 7 days from date না তাপতি সামন্ত learned advocate who represents so and so by 7 শেষে করে দাও by 7 days from date. Stop. That respondent alleged contempt 2 is still the administrator.
Administrator.
There is no change of administrator till date. As assistant inspector of schools, who is as the cadre. One assistant inspector of schools
attached to District Inspector of Schools AC Birbhum is the administrator of Metekona Maulana Abu Taher Senior Madrasa, Birbhum, being alleged container number 2. And said administrator is also not represented in spite of service of notice. Stop. Client advocate for the applicant is directed to serve another notice upon the administrator of aforesaid madrasa, enclosing copy of this order by fortnight from date. An affidavit of service to be filed on the and further affidavit of service to be filed on the next date. Next paragraph. In the event administrator of madrasa being alleged container number 2 is being alleged container 2 remains unrepresented on the next date, appropriate order to be passed ensuring presence of the administrator on the next date. Next paragraph. List the matter under the same heading for further consideration in the monthly combined list of January 2026. In the meantime, you obtain instruction whether after first month salary is paid or not. Next.
Item number 350.
My lord, I am appearing on behalf of the state, my lord.
Discount or state discount itself. Just a minute. The fixation of pay from 14 September 2007 has not been made.
Part of the order.
Arrear paid.
Arrear paid. But the fixation after payment.
So still you are getting salary in postgraduate scale of pay.
No, I am getting postgraduate scale of
So what fixation?
What fixation on and from the 14th September 2007 when I have joined in the second school.
Yes.
On that day, the postgraduate scale was paid. And I have joined in the postgraduate category. So prior to that period, my lord, on and from 14th September 2007 to my lord, 2nd August 2014.
No, area salary was paid for the period from 12th May 1999 to 13th September 2007.
That is been paid.
That was paid. Now there is a direction by this court to refix the pay of the petitioner from 14th September 2007. That is the date of joining the second school.
Second school?
Yes.
Till 2nd August 2000. By 2nd August 2000.
That is not directed. 14th September 2007, there was a direction from 14th September 2007 to refix the pay of the petitioner.
Refixed by the school also and sent to the commissioner, still pending before the commissioner.
Commissioner? Why not DI?
Through DI. It was submitted to the DI. DI has sent to the commissioner for
approval. Now, now you are getting salary in the postgraduate scale of pay.
I am getting.
So, refixation to what extent?
That period, my lord, the one on 14th September 2007 to 2nd August 2014, the postgraduate scale was paid. So earlier order was, my lord, the paid the, my lord, the TI has sanctioned. My lord, the
Yes, why you are not refixing pay from 14 September?
My lord, may I allow to make the submit the instruction, my lord.
What instruction? You show me that you have carried out the order. What instruction is required? Court is not going to hear this matter on merit.
My lord, I have already paid the writ petitioner the area amount.
That he is submitting that it is paid.
And
But
I
what
am-
about the refixation from 14 September, taking account of the postgraduate scale of pay allowed from 12 May 1999 to 13 September 2007?
My lord, already I have written to the school headmaster. Commissioner DIE has already written to the school commissioner. It is in the process, my lord.
How long it will take?
My lord, give me 4 weeks. I will complete this one, my lord.
So 2nd January 2025 order direction by 12 weeks it is to be completed. Now school has forwarded the papers as he
School has forwarded, DIE has forwarded.
Where is the difficulty?
Give me only 4 weeks, my lord. It's my humble submission before your lordship.
Matter is heard in presence of the learned advocates representing the applicant and alleged contemner. Stop. Next paragraph. It is submitted. So paragraph number they korbe hai 1, 2, 3, 4. It is submitted on behalf of the applicant that arrear dues for the period from 12 May 1999 to 13 September 2007
অপশন থাকবে আমি অন রেকর্ড করে দিচ্ছি
has already been released in favor of the petitioner pursuant to the order dated 2nd January 2025. However, other part of the order whereby concerned state respondents were directed to refix the pay of the petitioner from 14 September 2007 when petitioner joined the second school, comma, remains টা কেটে দাও, comma, is not complied with. Stop. Next paragraph. Mr. Shahi, learned additional government leader, prays for 4 weeks time to prays for accommodation koro. Prays for accommodation to comply the order dated 2nd January 2025 by refixing pay of the petitioner from 14 September 2007. Next paragraph. Hearing of this contempt application stands adjourned. List the matter under the same heading for further consideration in the monthly combined list of January 2026. Take steps in the meantime. Next paragraph. Alleged contemner is directed to file affidavit of compliance on the next date.
Deeply obliged, man. I will file, man.
Item number 351.
The content of the order of your lordship dated 24 June 2025, annexing page 60. The relevant portion is found in page 63, paragraph number 8 and 9. The concerned authority of the board.
Just a minute. Paragraph?
Paragraph 8 of page 63, my lord.
Paragraph 8 of the order.
Yes, ma'am.
Page 73.
63, my lord.
Order dated 24 June 2025.
My lord. Yes, that's in page
24 June, page 60.
Page 60, 61, 62, and 63.
Oh, this is a separate order.
Separate order. Well, this is connected with
Page 63, paragraph 8.
Concerned authority of the board is directed to take steps in terms of the directions as contained in order dated 13 June 2025, passed in Pompa Dattodhar Supra. Copy of the order dated 13 June 2025, passed in Pompa Dattodhar Supra, duly countersigned by the Assistant Registrar Court, be taken on records of each of the writ petitions. Thereafter, my lord, kindly come to next matter, that is Pompa Dattodhar, starts from
Just,
page
just,
64.
just. NIOS candidate for verification of documents. So your documents have not been verified.
Documents were verified. My lord, kindly come to page 60, page 76, paragraph 14. His direction were on two folds. One is, if your lordship kindly come to paragraph 14, your lordship will find, in view of the law laid down by the Honorable Supreme Court, it's in page 76. Page 76. Well, got paragraph 14. Very. In view of the law laid down by the Honorable Supreme Court in Suprita Chandel, Supra, and K.I. Shepherd, Supra, this court directs the board to treat the petitioners as similarly circumstanced candidates as appellants before the Honorable Supreme Court and verify the eligibility of the petitioners as an early date without disturbing the verification process which has been initiated in terms of notification dated 30th May 2025, which is confined to the appellants before the Honorable Supreme Court. Eligibility of the petitioners shall be verified provided they fulfill the conditions as stipulated by the Honorable Supreme Court in the judgment dated 4th April 2025 to the extent that petitioners were in employment on 10th August 2017 and completed 18 months DLED program through NIOS before 1st April 2019. Petitioners are also required to comply with the norms as prescribed in the notification dated 30th May 2025, issued by the Secretary of the Board after verification. After verification of the petitioners, a comparative merit chart is to be prepared for filling up the post of primary teachers in connection with 2022 selection process. After preparation of the merit chart of the petitioners, on completion of the verification process to be initiated by the board, petitioners shall be at leave to take steps in accordance with law. I am agreed by this portion, my lord. After verification of the petitioners, a comparative merit chart is to be prepared. That has not been prepared. for filling up the post of primary teachers in connection with 2022 selection process.
Contempt does not lie. No time-bound order is given. And your eligibility is verified already.
Well, there is a Supreme
Court has not directed to do this within certain time, knowing fully well, consciously this was not included in the order. When the chart will be prepared, if you will have your candidature will be considered based on the verification which has been allowed pursuant to the order passed by this court.
May I only say, my lord, there is a judgment of the Honorable Supreme Court in Kaushik Das. Your Lordship is aware about this judgment. I want to place one paragraph.
Not required. Kaushik Das was considered in Pompada.
Yes, fine. That
you are not, you are similarly circumstanced, but you are not an appellant before the Supreme Court.
Your Lordship,
considering the ratio of K.I. Shepherd and Suprita Chandel, I permitted verification.
Yes,
but I did not direct that within certain time to prepare.
Your Lordship was not directed to do it within certain time, but your Lordship has directed them.
And the verification has been allowed so far the applicant in this contempt application is concerned.
Verifications is done. That is done. But so far,
so to that extent, that is the purport of the order. What was the issue? That since you are not the appellant before in Kaushik Das's case, so therefore verification was not permitted.
Yes,
so far the other candidates are concerned. So therefore this court permitted verification. Now preparation of chart and publication of chart, that will be in accordance with law by the West Bengal Board of Primary Education, for which considering this order no contempt lies.
Lordship, so far if your Lordship hold that also, that after verification of the petitioners, the comparative merit chart is to be prepared for filling up the post of primary teachers in connection with 2022 selection process. After preparation of the merit chart of the completion of the verification process to be initiated by the board. So this was also direction Lordship passed, but no time was admittedly given. But Lordship, so far this direction is concerned, this is also, in my reading, subject to correction, that this is also part of your Lordship's direction.
I delivered the judgment in open court after hearing in Pompada. Only issue is verification. In addition thereto, I gave certain directions, but consciously I did not indicate the time.
Lordship, but
contempt application is hard in
Lordship, there was a time.
You are not a party before the proceeding in the Supreme Court.
But there they said
that's why you have initially you are not permitted to have your testimonials verified.
So then your Lordship has bridged that gap. Your Lordship allowed us to
only verification up to the yes. If your verification was not allowed, I would have interfered in contempt.
But Lordship, if your Lordship is not inclined to admit this petition under the contempt jurisdiction, kindly your Lordship clarify that so that I can avail the other.
Yes, that is always
kindly clarify that, Lordship. That will.
Learned advocate representing the applicants alleges violation of the order dated 24 June 2025. Passed on batch of writ petitions. Your order dated 24 June. Batch of writ petitions. Stop. It is submitted by Mr. Chatterjee, learned advocate representing applicants, that order was passed on 24 June 2025 based on ratio decided in batch of writ petitions, first one being WPA 6695 of 2024, within bracket Pompa Dattodhar and others versus Union of India and others. Vide judgment dated 13 June 2025. Vide judgment and order dated 13 June 2025. Stop. it is contended as the directions contained in Pompa Dattodhar Supra it is contended in terms of the directions as contained in Pompa Dattodhar Supra. Alleged contemners are required to alleged contemner is required to prepare a merit chart based on verification of testimonials of the candidates. Similar direction is applicable in case of the petitioners in terms of the order passed by this court on 24 June 2025. Stop. It is also submitted on behalf of the applicants that in terms of the order dated 24th June 2025, testimonials of the petitioners were verified, but comparative merit chart is not prepared, which prompted the applicants to approach this court with the present contempt application. Next paragraph. On conjoint reading of judgment and order passed in Pompa Dattodhar Supra and order passed in case of the petitioners on 24 June 2025, and taking note of the submissions made on behalf of the applicants, it appears that order dated 24 June 2025 is complied with, as applicants were permitted to verify their applicants were permitted to verify their testimonials in connection with selection process of 2022 for filling up posts of primary teachers. Stop. However, next paragraph, for preparation of comparative merit chart based on verification process, no time was fixed by this court, vide judgment dated 13 June 2025 in Pompa Dattodhar Supra. Stop. Therefore, even ratio of Pompa Dattodhar Supra is applicable in case of the petitioner, taking note of the order passed by this court on 24 June 2025, comma, contempt application is not maintained. Next paragraph. Contempt application, next paragraph. Hence, contempt application stands dismissed. Next paragraph. However, this order shall not preclude the applicants to take steps in accordance with law relating to the selection process of 2022.
For the purpose of lordship preparation of the chart. if you-
That liberty is always there, is there in Pompa Dattadhar.
I understand what is going on.
Only issue was verification. এই ডাকো Call the list.
Item number 368.
68. ও এটা হয়ে গেল কন্টেম্প সার্ভিস। তুই কি করে দিলি? Yes.
My lord, I'm for the petitioner. My lord, this matter is listed under the heading applications, and all three applications has been disposed of, my lord. My lord, if lordship pleases, kindly list the matter under hearing, my lord. The matter is ready for hearing.
At present, I am not including any hearing matters because I have refused the mentioning of other advocates. It has brought to the, it is included in the list under the heading application wrongly, since applications have already been disposed of.
Yes, ma'am.
Issue. When I will permit mentioning for inclusion of hearing matters, you mention the matter, I will. Writ petition of 1999.
Yes, my lord, it's an old matter, my lord. 1999.
It appears on perusal of the order dated 18th August 2025 passed by a coordinate bench on the connected applications that applications being CAN 2 of 2021, CAN 3 of 2025 and CAN 4 of 2025 were disposed of. Stop.
matter has been matter is included in today's course list under the heading application quote unquote wrongly. Next paragraph, list the matter under the heading hearing in the monthly combined list of January 2026. Hearing এ দিয়ে দেবে 99 সালের মামলা।
Item number 369.
But at the outset, I humbly submit before the lordship. By mistake, I could not bring that affidavit of survey, but it is getting affirmed. I can file it within few minutes.
Other side is not there.
We have personally rang him.
Lordship, I'm for the respondent company, Lordship. Lordship, in this matter, Lordship, our brief has been misplaced, Lordship. So I'm asking to serve a copy so that I can appear, Lordship, and I can take some instruction.
Resolution I have served. I can prove it if I file.
Actually, I have misplaced, Lordship. I'm not.
He is praying for time that his brief is missed.
I understand.
1 week accommodation, so that I can appear apprise before your Lordship. And I will take instruction that
when it
no,
was
we will bear
dismissed
the
for
cost, Lordship. We will bear the cost.
But it was dismissed for default on 16th July, unfortunately, 2024.
Actually misplaced. And I will bear the cost, whatever may be cost for the Xerox.
and you have filed it after more than a period of 1 year.
Lordship.
Yes.
It's a long
we
pending
could
matter.
detect-
Lordship. It's a long pending matter.
We could detect only after about a year when we really took steps to get the matter listed.
Then serve notice. I am contemplating to dispose of this matter since this is filed after a period of 1 year. Order was passed on 16 July 2024
Yes.
and the application was filed on 28 August 2025.
2025.
Issue. Land advocate representing the company.
Yes.
Medical and Allied Industrial Limited. Why it is service matter?
My lord, he was serving as a manager in that company.
And
And
what is your grievance in the writ petition?
Once was that gratuity was paid, but the interest was not paid. After a long period of gap, I am of the agreed that I am entitled to interest.
Land advocate for the land advocate for respondent number 2, 3, and 4 has prayed for accommodation. So, however, applicant is represented by land advocate. Next paragraph. List the matter under the same heading for further consideration on 12th December 2025. You get the affidavit of service affirmed and serve a copy of it.
Should I file another affidavit of service?
That is up to I am not to advise you to take steps. Supplementary list next Friday.
Next Friday. Much obliged.
Item number 370.
But I am for the petitioner, my lord, restoration application, my lord, dismissed for default on 14 November 2025.
Affidavit of service.
The affidavit of service has not yet been affirmed, my lord. I shall file post of the date.
You are representing whom?
এই এটা ভিডিওটা অন করে রেখেছে কেন? যখন উনি অ্যাপিয়ার করবেন সেই ম্যাটার অন করতে বলো। ইন হুইচ ম্যাটার? না, প্রথম থেকেই চলছে এটা। কি করে হয় সেটা? না, already here he is not on he is not visible. কি করে appear করে? হ্যাঁ, he is not entering appearance, not submitting anything. এ কি? Yes, you are appearing in which matter?
My lord, I will be appearing in item number 372, just after 2 matters. My lord, I will come back at that.
Why you have indicated that you are appearing from 368?
No, my lord, that was, I said 372, my lord, the list would be called on 368. So by mistake, my lord, it has been said like, my lord, it has been said so 368. From onwards, I will appear on 372.
372 he is appearing.
My lord, I will come back. I will
You
not
should have indicated appropriately.
My lord, there was
While
a
logging
typo.
in.
My lord, there was a typo mistake, my lord. But I'll come
Otherwise,
back.
there will be confusion.
Lordship, absolutely, absolutely, absolutely.
So you're representing both the applicants, both the respondents, alleged contemners. You are representing both the alleged contemners. What is your name?
Ananda Dural Sarkar and now engage Sushant.
Where is Mr. Pal?
Engage another.
Can 2 of 2025 is for recall of the order dated 14 November 2025. Stop. Alleged contemner, next paragraph. Alleged contemners are represented. Next paragraph. Having perused the explanation in the application, it is found that applicants were prevented by sufficient cause from being represented before the court when contempt applications stood dismissed for default. Stop. Order dated 14 November 2025 is recalled. Next paragraph. Contempt application is restored to its original record, original file. Stop. Application being can 2 of 2025 is allowed and disposed of.
My lord, may kindly list the matter, my lord. It was already appearing in the list, my lord.
Yes.
My lord, may kindly list the matter, my lord.
Contempt.
Yes, my lord. It was appearing in the monthly list, my lord. I missed it, my lord.
Next paragraph. Let the contempt application appear under the let the contempt application appear under the heading contempt application quote unquote in the monthly combined list of January 2026.
Obliged.
Next. This is a contempt application arising out of which order?
My lord, the
Order passed by which court?
order passed by Justice Nizamuddin, my lord.
Oh, তাহলে old contempt করে দেবে।
Item number 371.
My lord, I am for the petitioners.
I appear for the alleged contempt.
এটা 370 হলো।
My lord, we could not comply the court's order to substitute the name of the legal here.
Just a minute. Can one of our device for substitution of is okay. So substitution.
Yes.
My lord, we could not comply the last court's order to substitute the name of the legal heirs. That is, lordship, please extend that time.
Why? Order was passed on 7th November, 1 month back.
Process is not completed.
Whether other heirs, there are 7 legal heirs, out of which one has made an application seeking substitution. So what about the 6 other heirs? They are not interested.
No, they are not interested. Only change is required.
Only
Name will be changed. The legal heirs.
that court knows that the name will be changed. But what about the other 6 heirs? Where is Mr. Go Thakurata?
He is now in the division bench. Praying for
Hearing of this matter stands issue. Order. Matter is called on for hearing. When submissions are not made, disclosing the steps taken in terms of the order dated 7th November 2025. Stop. Alleged contemner is represented by learned advocate. Next paragraph. Accommodation is paid for on behalf of the applicant. Hearing of this application stands adjourned. List the application under the heading application on Friday next, 12th December 2025. Tell Mr. Go Thakurata to appear.
12th.
Item number 372.
I appear on behalf of the respondents, Your Lordship.
Appearing in behalf of petitioner, my lord, Mr. Debojyoti Basu is leading us. He is in virtual mode.
I'm playing for a short accommodation. I'm being led by Mr. Varun Kedia in the matter. He's unable to appear before Your Lordships just for today.
Where is he?
I'm told that he had to go out of station for some personal grounds, Your Lordship. I'm praying.
May I have privilege to address Your Lordship?
What is the application for?
The application, there are 2 applications. One for further order, in the guide of seeking interim order. On the 2 grounds, on the day of admission, there was a specific directions upon the respondent to come up with a composite opposition dealing my writ petition as well as a supplementary affidavit. Number 2, considering the given facts of the case, the coordinate bench, though considered not to pass any interim order on that day, but kept my space open and granted me liberty to come up with an application for seeking interim order if any subsequent developments have come up. Now,
but today, on behalf of Coal India, you are representing Coal India. Accommodation is paid for on the ground.
I understand. I understand. I do not wish to put Your Lordship in amiss. Only the thing is, that why I am seeking interim order, because of the fact that though, in the writ petition, the substance is that there has been an arbitrary discrimination with regard to selection process in respect of a promotion, and similarly circumstances people where we do belong, we are being eliminated, and other persons somehow in a different list though on the same category, they are intending to give promotion, and that is the cause of action before Your Lordship to file this can 1, where we seek there has been some protections to be given, because the person, and they admitted through their RTI that despite a pendency of the writ petition interregnum, they are seeking a departmental promotional committee whereby they intend to promote some persons other than us, which are similarly situated. That is the urgency, I understand they are taking time, kindly keep it in a, if Lordship, at least protect us. On the contrary, if not today, then keep it in a according to Lordship's convenience, so that I can come up and place my case for some equitable consideration. And
Your Lordship.
can 2
Why
is this.
two applications?
Yes, can 2 is this. There is another applicant who at the time of filing of the writ petition could not join in hands with the petitioners, who also being similarly placed, similarly aggrieved, on the similar facts and circumstances. So instead of filing a separate writ petition, he chooses to come up and join in the array of the petitioners. That can 2 is there. There are sufficient pleadings, Lordship. So, by other than filing a separate writ
No, whether the
petition,
promotion has been granted to other batch of employees.
No. They have said, we are in a process. Your Lordship may kindly see, that is the urgency why we have come up. Annexure, A5 to Can 1, would possibly, if that be so, if your Lordship kindly see, before looking into E5, kindly see paragraph 8 of my Can 1 application. Kindly see, paragraph 8. I have made substantial pleadings and support of the documents in this regard. Has your Lordship come, E5, that lately the applicants have come to know the respondent departmental promotional committee such and such. Promotion orders are being given. Now, is A5, that would be pleased to find. Yes, from at page 34. Kindly comes to page 36. The cater schemes promotions, this procedure, how this they have seeking to adopt, which may your Lordship, how we do we get this in terms of as RTA application. Initially we were not given. Subsequently, at page 34 on 19 July, this was been given. If your Lordship kindly comes to page 35.
In the writ petition, you have challenged the provisional seniority list dated 2nd May 2013, based on which promotion was granted.
Yes, that was one part. So far, the other.
No, that is the only part which appears from the order of the coordinate bench.
Lordship.
So then, where is the reason to file an interim application at this stage?
No, so far as if your Lordship see,
already promotion has been granted based on provisional seniority list dated 2nd May 2013. What really we have sought for in this application? Let me see.
My lord, sorry, my lord, there was possibly some technical glitches, my lord. I could not hear your Lordship.
So now you are praying for stay of the promotion from E5 to E6 in the excavation
Exactly.
grade due to
Exactly.
pendency of this writ petition. On what ground? Why court will interfere at this stage? Because your right,
That is why
your right consent on the basis of the order, on the basis of the provisional promotional order, which has been referred to in the order of the coordinate bench. It is stated.
Yes, Malad, with regard to the on this honorable court, Malad recorded Malad one part. Malad, so far my repetition is concerned, Malad, I do not stand in other way. Lordship kindly takes up my repetition, prayer A. Kindly takes up Malad, prayer A at page 26. There is a twofold submissions, my lord. One with regard to the professional senior list of May 2, 2013 and subsequent professional seniority list based on which the promotion is sort of given.
Provisional seniority list dated 2nd May 2013 based on which promotion was granted.
No, that was
you
one.
have challenged this 2nd May 2013 provisional seniority list by filing a writ petition on 12th February 2025 after 12 years. After 12 years, court considering this aspect directed to exchange affidavits. Now, in the meantime, you are praying for stay of further promotion from E5 to E6 since
E6?
your writ petition is pending.
No, because of the fact, my lord, that in pendency of the writ petition, your lordship, my lord, has seen, if my lordship has kindly read the order in other way, my lord, I believe your lordship also would appreciate that part also. See the penultimate paragraph of the same order by the coordinate bench. Considering any further development, kindly, my lord, have a look to this. Because and this is in apropos in consonance with my prayer A to the writ petition, that there should not be any promotion further. Kindly see, my lord, the last paragraph.
Yes, that I have seen.
Yes.
That I have seen, but why court will interfere relating to promotion from E5 to E6? It has a cascading effect since you have approached this court after 12 years and your writ petition is pending. Then I will stall the promotional process, which is initiated by the Coal India.
No, my lord, that this promotional process is not in effect of 2013. This is the effect of
which I understand. That I understand that is not in connection with 2013. It is in connection with the subsequent promotional process. Why this will be stalled?
No, my lord,
ultimately, if your writ petition is allowed, then you will get the consequential benefit, if necessary with retrospective effect. But in the meantime, the subsequent promotional process, which might have been initiated in 2025 or 2024, that should or not to be stalled.
Well, that has all been done after filing of the writ petition. Well, what we say, well, we are being wrongfully excluded from being. Well, I know that for getting a promotion is not a matter of right, but I have a right to be considered. This is also a settled law. Your lordship
for
has
consideration of your right, if you are an eligible candidate, apply for the promotion. If you are not eligible, don't apply for the promotion. Because if your right hinges on the outcome of this writ petition which is pending, then in that event you cannot apply.
Yes,
so therefore, subsequent promotions, court should not stall at this stage. Since your writ petition is pending and which appears to be a belated writ petition.
My lord, one more submission. I would not take more than 30 seconds. Lordship has considered. Lordship's court is a court of equity, but it is an equitable jurisdictions. Considering the given fact, Lordship can also mold the relief in order to ensure that in future, whenever the writ petition is disposed of in either of the way, it may not become infractious. Kindly give me a protection to that extent, This is my humble prayer. So that
court has already passed, a coordinate bench has already passed an order. It is a writ petition which was filed. Try to appreciate the predicament of this court also. There is writ petition was filed in connection with a provisional seniority list of 2nd May 2013 in 2025.
Only to the extent that the petitioners in the event succeed, they would be to the extent kindly give me that protection. That so that in future there may not be a multiplicity of proceeding. This is one part, Second part, despite of the direction of your lordship, they have chosen not to file any affidavit.
1 of 2025 and can 2 of 2025 are taken up for consideration.
Can 2 is different.
In presence of the learned advocates representing the applicants,
and Coal India Limited. Stop. Mr. Debojyoti Basu, learned advocate, appears on behalf of the applicants on virtual mode and has made submission. Stop. On next paragraph, on perusal of relevant records available and the submissions made on behalf of the parties, it appears that the writ petition pertains to promotion which was denied to the petitioner based on provisional seniority list dated 2nd May 2013. However, writ petition was filed 12 years thereafter on 12th May 2025. Stop. A coordinate bench by passing an order dated 5th May 2025 directed the parties to exchange pleadings and matter was also directed to appear under the heading hearing. Stop. On behalf of the applicants, reliance is placed on part of the order dated 5th May 2025 passed by the coordinate bench, whereby leave was granted to the petitioners to apply before the court seeking necessary interim relief if situation so arises. It is contended that a promotional process is initiated by the concerned authority of Coal India Limited for promotion from E5 to E6, capital E5 to capital E6 hyphen E6 hyphen E5 E hyphen 5 E hyphen 6 E6 grade, E5 to E6 grade. Stop. Prayer is made in the application being Can 1 of 2025 to stay such promotional process from E5 to E6 grade due to pendency of the writ petition. Next paragraph. Writ petition was instituted since petitioners were not promoted based on provisional seniority list dated 2nd May 2013. Stop. If ultimately writ petition is allowed, right of the petitioners relating to promotion, to the right of the petitioners for being promoted to the next higher cadre can be protected by passing appropriate order.
I'm extremely grateful, extremely grateful.
Which may also have cascading effect.
Stop. However, this court finds no reason to interfere with promotional process initiated by the concerned authority of Coal India Limited. During pendency of this writ petition. Stop. Hence, the application being CAN 1 of 2025 is dismissed.
But one prayer, this CAN 1 is based on two folds. The coordinate been directed to file their affidavit
In
on
terms
the
of the order
that they have
dated
not filed.
5th May 2025, writ petition shall be heard. Writ petition needs to be heard.
I'm grateful.
Pleadings are complete.
No, Miller, that is why I say
Affidavits are complete.
they have failed. They have failed
It's
to
ready,
file
but
any
the
affidavit.
supplementary affidavit brought forward some documents which required some clarifications. Just a short time is required.
Well,
We'll be
in
filing it
terms
very
of the
soon.
Supplementary
direction,
affidavit is to be filed by whom?
by us, Miller, we have filed, Miller.
In light of the supplementary
Needs to
affidavit,
be heard.
we will be
Next
filing it
paragraph.
shortly.
Today, supplementary affidavit is filed on behalf of the petitioners.
No,
Same
Miller.
on record.
Miller,
Where
am I
is your
audible?
affidavit in opposition?
We will be filing it shortly, Your Lordship. We are in receipt of this
Stop.
supplementary affidavit.
Miller, am I audible, Miller?
Respondent authorities are directed to file affidavit in opposition by 7 days from date.
I'm grateful.
By 7 days from date, and time to file affidavit in opposition stands extended. Stop. Time stands extended. Time to file affidavit in reply is also extended. Thereby, leave is granted to the petitioners to file affidavit in reply by 1 week after ensuing Christmas vacation.
I'm grateful.
So, after exchange of pleadings are complete, after exchange of pleadings is complete, petitioner shall be at liberty to mention the matter before the appropriate bench for hearing. Next paragraph.
Miller, am I audible, Lordship?
At this stage of the proceedings, court does not find it fit to allow the application being CAN 2 of 2025, whereby prayer is made by another, whereby prayer is made by the applicant to be impleaded as party to the pending writ petition. Stop. Hence, application being CAN 2 of 2025 is dismissed. However, this order shall not preclude the applicant to file an independent writ petition.
I'm grateful.
For vindication of his right in connection with promotion.
Miller, am I audible, Lordship?
Urgent xerox certificate for promotion.
Miller, am I audible?
Yes.
Miller, one prayer, Miller, since your Lordship for the in CAN 1, Lordship has dismissed, Miller, but the other folder of the prayer, Miller, since they have chosen not to file affidavit, and your Lordship has given, Miller, consequent directions, Miller, dismissal, Miller, what, Miller, may term to otherwise, Miller, may it be in terms of dismiss, may be disposed, subject to your Lordship considerations, Miller. And
how
Miller,
that can be? But I have granted the applicant in other applications seeking implement to file an independent application, writ petition.
Lordship. That can 2 have seen, Miller. That
Yes.
can 2. And so far as CAN 1, Miller, one more sentence, if subject to my lord's kind conditions, Miller, that if it, my lord, is all promotions, my lord, up to, my lord, is subject to result of the writ petitions that your petitions, my lord.
Mr. Basu, in case of promotion, ultimately, if your writ petition is allowed, then you will get the benefit. And I have stated with cascading effect.
Cascading effect. I have heard.
But therefore, but for that, all subsequent promotional process should not be stalled.
Should not be stalled, but cascading effect, my lord, they all of them have to suffer. Have to suffer, my lord. Have to suffer. I mean, one last directions, my lord, I am saying too much, my lord. Lordship is kind enough. My lord, there has been my learned friend for the adversary. They say that supplementary was not received. It is incorrect. It was served in June in terms of the coordinate bench directions. They sat tight. Lordship has given further directions, may it be peremptory in nature, so that immediate after filing of the pleadings are
ওখানে যে অ্যাফিডেভিটটা করলে না, ফাইলিং অফ অ্যাফিডেভিট অন এক্সটেনশন অফ টাইম যেখানটা বললে, extension of time granted in favor of the parties to file affidavits of time granted in favor of the parties to file affidavits is peremptory.
I'm extreme deeply.
ওই যেখানে এই সাপ্লিমেন্টারি এফিডেভিট এক্সটেনশন অফ টাইম সব বললাম, তার শেষে এই লাইনটা অ্যাড করে দেবে।
I'm deeply oppressed.
7 days, not before that, not after that.
Extremely grateful.
Yes.
Item number 3 from daily list.
Yeah, I am for the petitioner. Well, this is the matter that related to your lordship's pass and order. Well, this is the rounding of 169.5 and above to 170. Well, the initial order not maintainable.
Yes.
In initial order is our maintainability point.
169.4.
Well, kindly come to page 22 of my return.
Just a minute, let me go through my own order. If it is 169 for
No, he is 169.4.
Then nothing can be done.
Nothing can be done. Well, kindly come to page 22.
Just a minute, revenue service filed on the Yes,
Come to page
22.
20 of my return. Is the height, left hand side, 169.1, first instance. And then your losses kindly come to page 52.
Page 52.
Page 52 of my writ application. Right hand side, obtain 169.5.
Okay.
Required 170. Right hand side.
Yes, Mr. Ladi.
Kindly comes to 48. Otherwise, I would have not raised this.
So why two different heights?
I do not know.
Yes, this is what happened. After
no, there are 4 petitioners in this petition.
Only one,
only one, Swagato Hazra. My lord, I am clarifying my learned friend's confusions. My lord, page 22 was the first instance when my candidature was rejected on measuring me 169.1 centimeter. Then I preferred a writ application before this honorable court. This honorable court was pleased to direct the respondent authority to consider my appeal for remeasurement. In the remeasurement appeal, they have first instance measure me as 169.4. That is what is my learned friend is referring, page 48.
Kindly see the time.
And
1755.
And next 52 page. 52,
Page 48.
48. That is the first instance of after the direction passed by this
তাহলে তো
honorable.
কিছু করার নেই।
And
You'll get the
second
benefit.
instance 52, page 52.
Order, same order as others.
What is that order?
Well, that is the 3rd December order.
Mr. Lyrie, let them participate in
Yes,
the.
yes, I am not.
Dada,
We have only given.
No, but why two measurements?
I don't know.
My lord, they
So in terms of the order, then in terms of that order,
they have allowed me to remeasurement as appeal.
Two times
as
are
appeal.
given.
দাঁড়ান,
So,
বলে দিচ্ছি
আর
স্যার।
ঠিক আছে বাবা, আমি allow করে দিচ্ছি
হ্যাঁ।
তোমাদের ওই allow।
না সে ঠিক আছে কিন্তু জজ সাহেবের they once allowed, then I orally made an appeal that my height measurement is less than 155 required height measurement. You preferred me, you allow me to file another appeal. They allowed, and this is the order passed by the appellate authority on the same date. After passing this order.
what is going on?
My lord will pass the same order
And
as
that has been increased.
and keep it on the 18th.
Yes. Matter is-
Must have been.
नहीं होगा भाई। ये बाउंड
It is not in review, in appeal.
Yeah, appeal. In physical test, it is appeal, and medical test, it is review.
— 169.5 centimeter,
5
He is 116.5.
which is less than 170 centimeter. This is to be corrected on the next step. It should be 170 centimeter. So, Lyrie,
তুমি ওই তারিখে অর্ডার দিয়েছো, এই অর্ডারটা দিয়েছো তিনবার।
আপনার
ওদেরগুলো একই অর্ডার।
so supplementary affidavit here is not required.
No. Paragraph 8 and 9 is not required.
On 18 December, let it be, along with other matters. Same order, এই শুভেন্দু, এটা দেখে করে নেবে, একটা ভুল ছিল ওই অর্ডারটা, এটা 170 সেন্টিমিটার হবে, বুঝতে পেরেছো? আর এইখানে এই প্যারাগ্রাফ 8 আর 9টা হচ্ছে না, আর একই ডেট ফিক্স হচ্ছে 18 ডিসেম্বর। সেম অর্ডার,
Same order in 3, 4 and 5.
one after another.
One after the
Yes, next.
Item number 4.
4, may I please, Your Lordship, it is page 38.
Every day these matters are being mentioned. Since your last date is 9th, medical examination last date is 9.
No, it goes on. You can go on.
It will go on.
It will
In
go
the
on.
So it is not that it will be
No, stop.
closed on 9.
Yes. Here also 169.5.
No.
Page
36. Page 36.
36.
38.
Rubel to.
38, page 38, 169.8.
Oh.
Rubel Islam.
38.
ওই আবার নিয়েছে।
এই শুভেন্দু সেম অর্ডার হবে, 169 দেখো এখানে একটু হাইটটা বলা আছে এটা তুমি শুধু না
মেজারমেন্ট নিয়েছি
ইয়ে অনুযায়ী ম্যাটার অনুযায়ী একটু লিখে নাও এই হাইটটা চেঞ্জ হতে থাকবে এইটা এখানে হচ্ছে 169.8 সেন্টিমিটার একটু নোটস করে দিচ্ছি। Yes, same order. 18 December.
Item number 5.
119
Yes, my lord.
কপিটা তুলতে দাও
Here page 119.
119
My lord, last petitioner is surviving in this petition because the joint petition. Jagannath Ghosh.
আর একটা জিনিস দেখবে প্রত্যেকটা না জয়েন্ট পিটিশন ছিল পরে একটা করে পিটিশনারের ক্ষেত্রে এটাকে এন্টারটেইন করে বাকিগুলো ডিসমিস করা আছে এখানে যেমন পিটিশনার নাম্বার 16 পিটিশনটা এন্টারটেইন করা হয়েছে বাকিগুলো ডিসমিসড বুঝতে পেরেছো এটা একটুখানি এটাই লিখে রাখুন
না অনলি ইন
ওটাতে পিটিশন হিয়ারিং আপনার রেফার টু পিটিশনার করা আছে সুতরাং নেক্সট অর্ডার ওই পিটিশন নাম্বার 16 হিয়ারিং রেফার টু পিটিশনার করে দেবে হ্যাঁ এখানে পিটিশন নাম্বার 16 দেখে নেবে পিটিশন নাম্বার 16 হিয়ারিং আপনার রেফার টু পিটিশনার হ্যাঁ 16টা পিটিশনার তার মধ্যে 16 নম্বরকে পিটিশন নাম্বার 16 ইয়েস ওয়্যার ইজ দ্য মেজারমেন্ট 109
119.
119
in this matter let the department correct the otherwise it will be
yes
the matter is coming in the name of the first petitioner in the list also let that be changed by an order otherwise it will be very difficult because the rest are all petitioner number 1 only in this case
This case only petitioner number 16. Last petitioner.
right it is 119
119.
page 119 169.5 আমরা তো দিদি কে আলাদা করে এটা 150 টাকা ঠিক আছে
169.5
Yes.
169.5 সেন্টিমিটার আচ্ছা এখানে একটু এসো এটা অ্যাড করে দিই কি বলেছো
এই মৃণাল কোথায় গেল দিয়ে দিন তো মৃণাল
শেষে অ্যাড করো by order dated 26 November 2025 present writ petition is present writ petition was found to be maintainable at the instance of petitioner number 16 and it was dismissed so far other petitioners are concerned stop in terms of the order dated 26 November 2025 department is directed to amend the cost title by striking off names of petitioner numbers 1 to 15 from the array of petitioners by 7 days from date and cost title of the writ petition as delineated in the present in the pro forma page and the back page of the writ petition needs to be amended accordingly. Top. Learned advocate representing the petitioner is directed to cooperate with the department to incorporate necessary corrections in the writ petition.
Much obliged.
Item number 6.
My lord, item number 6, your lordship picks up on the last occasion. My lord, I have shown your lordship and direction passed by this honorable court, wherein, my lord, we were directed to go for an, my lord, measurement. Now, my lord, in that case,
by which order this court directed to go for measurement?
Yes, my lord, I will show to your lordship.
27 November 2025. Yes.
3/10/25.
Just a minute.
Page 25. My lord, what happened is in the
just a minute. Just to relaxation from height. With the relaxation to be extended in the petitioner.
As height of the patient was minus. Let petitioner be medically examined and the matter to appear on 18th along with other matters.
That is up to you, but Lordship, there is, I would
Yes,
like
yes.
to.
What else you want to submit? Till yes.
Therefore-
Anything you want to submit apart from this?
Lordship, yes, Lordship.
yes, what is
Actually,
it?
on the other day I had started my submissions when I had taken time to improve my submissions, if
Yes,
your Lordship
I do
recall,
remember. Yeah.
that why I was insisting on this relaxation cannot come at the stage prior to medical. Lordship, that is what I was, I had tried to impress upon you, Lordship. Lordship, I'm just I'm handing over, Lordship, copy of the advertisement, Lordship. This is just to, if your Lordship takes, this is the first page, where after the notice, application forms are accepted. First stage is clause 13, the computer-based examination. Lordship comes to the last paragraph, found it?
Yes,
So stage 1 is computer-based. Then comes stage 2, after computer-based, it comes to, there's a, Lordship, there's
Physical standard test.
then we have the running, the physical eligibility, when everybody has to run the race and the candidates are given at the stipulated time, Lordship. There is a particular time for the general people, particular time for Ladakh people, and for various regions, Lordship. Then, Lordship, the physical standard test. Lordship, physical standard test, the benchmark is male 170, female 157, and the relaxation comes in the question of, Lordship will kindly see, I'm not detailing it out, all candidates, scheduled tribes, the Garhwali, Kumaoni, various tribes have got their various stipulations for the height of a male candidate and the height of a female candidate, Lordship. So these are the three tests. Then we come to chest. So after running, the height, and thereafter the chest measurement. Now, chest measurement also, the measurement is given. Now, Lordship, if we come to the question of weight, it says proportionate to height and age as per medical standards.
That means BMI.
Then we enter into the medical test. Lordship, this is why I'm trying to say that the advertisement has stipulations. That you have to give your written test, then you have to come in for the race. Race you have to complete within a particular time. Then otherwise you're eliminated. Then comes the height. Height also as per stipulation. I mean, either you show a certificate to show that I'm from an exempted category where I get some concession, or that benchmark is 170 or 157, whatever it is. That is where that is being done. It is not the stage of medical. Now, when comes the question of weight, Lordship. This is why
weight is measured at the time of physical standard test.
No,
yes.
No. Weight comes thereafter, Lordship. Now, Lordship, I'm just handing over a copy of the, Lordship, it might be with your Lordships, but I'm handing over the guidelines for your Lordship. Sorry. Lordship, Lordship, we are going to come to 2D, Lordship. Now, next page, Lordship, 2D. Now, Lordship says, measurement of physical standards, that is height, weight, and chest, is the responsibility of the Physical Standard Test Board for all categories of candidates, that is the GOs, etc. Medical officers will not be a part of the PST board, both for male and female candidates. Since then, the presence of female, I'm skipping that part, Lordship. recruitment.
No, please read it in a
Okay,
sentence.
I'll tell you, Lordship. Since presence of a female is required at the time of recording a physical standard, a female non-medical staff may be associated with the PST board. Recruiting medical officer need not record physical measurements. Recruiting medical officer will mention physical standard in the medical examination form as recorded by the PST board.
So therefore, 2D starts with a
Lordship,
stipulation.
Lordship, I have
2D
to
starts with a stipulation measurement of physical standards, namely height,
PST.
weight, and chest.
Where it comes with the PST, Lordship. Now the recruiting medical officer will mention physical standard in the medical examination form as recorded by the PST board. In borderline cases of overweight, Lordship.
Recruiting medical officer will mention physical standard.
In the
medical officer will mention physical standard in the medical examination form as recorded by the PST.
So at the initial threshold, what is happening here, Lordship, it's a PST who measures, and in my humble submission, since the advertisement gives a particular figure, the board is not empowered to change that at that stage. Everybody has to reach that standard. For the test, the standard has to be reached. For the run, the standard has to be reached. For the height also, the standard has to be reached. The board there cannot be flexible. Now the question of flexibility comes in. In borderline cases of overweight, BMI should be considered to arrive at a conclusion at the variation of 5 kg plus minus from the minimum maximum limit may be accepted. Similarly, while measuring height fraction from centimeter less than 0.5 will be ignored and 0.5 and more will be rounded off to the next higher centimeter, standard height weight chart is attached at annexure 1. Lordship, this is the chart, Lordship, if your Lordship then kindly comes to annexure 1. Lordship.
Page?
Lordship, annexure
Annexure 1, page 46.
Yes, Lordship. This gives the height in centimeters. The first page is for the male. And Lordship sees it starts from 156. This is where the Garwalis, these are the heights. It's not, everybody is not uniformly 170, Lordship. The heights vary according to the tribes, according to the people, according to the stipulations in the advertisement. So height, and then comes for the female candidate. Now, Lordship, the question comes. I was trying to, now, when a person is overweight, Lordship, now they have the standard weight that a person should be 18 to 22 years. The weight should be this. That is a chart. Now, supposing a person is overweight. This is where the question of rounding off the weight and then bringing it into an accept, because the chart says it has, then that is where the rounding off and adjusting the height.
How this rounding off is to be made?
Yes, at this point of time.
In order to bring the weight of the candidate within the prescribed parameter.
Lordship, this is what I had asked, Lordship. Weight does not have a parameter in the advertisement. The height does.
Suppose 172. Come to this chart.
Now, if the 172 person, Lordship,
172.
I shall give a chart where I think this is just a chart I had prepared because I had to try to understand. Supposing a person is
hypothetical chart.
This is hypothetical. Now, Lordship, see the chart. The black ink is the chart of the medical guidelines, right? So 172 person, let us say he is overweight by
173 by 1 kg.
No, he's 54 to 66 is what he can be. A 22-year-old boy should weigh 54 to 66. Lordship sees the age is 18 to 22. 18 years. That is the chart. 18 to 22.
If his height is 170,
height is one.
If height is 170, then his weight should be 52
to 64. Now, if his weight is more,
If it is higher than 64.
If it is higher than 64, his age is 18 to 22, he is higher than 64, then the question of plus minus 5 kg.
How this plus minus is to be made?
Lordship, and rounding it up to the, then they bring it into the next level, next category by adding that point. Then Lordship, then it is supposing.
Then Miss, also apply your mind.
Lordship.
Miss Alam.
Yes.
170 is the prescribed height.
170 is the prescribed height.
For a candidate within the age group of 18 and 22, his weight should be 52 to 64.
Lordship.
Suppose a particular candidate weighs 67.
67. So we can.
And if it is found this height is 170.8.
Then they come into the BMI index.
Or if height is, suppose his height is, yes, 170.8.
Lordship.
Now the prescribed height is 170.
It can be more, but cannot be less.
Yes.
So 170.
Yes. Prescribed is 170. So it can be brought down to 0.8.
Lordship, what I'm saying is, Lordship,
it can be brought down to 0.8.
Lordship, the height, in my humble submission, we are putting him into a BMI zone. Now the weight, Lordship, it is expected. It can be, because Lordship, once a person reaches the medical stage, after passing all those stages, neither do we want to unnecessarily eliminate people. And a person who is overweight can always become, he can check his weight. We can always, he can trim down, he can lose his weight.
In calculating BMI,
yes,
you will find that the
ratio
is factors are weight, height. Weight and height.
Weight and height, there is a ratio.
Now, so far weight is concerned, if weight is more than the prescribed limit, then weight has to be adjusted within the prescribed limit by adjusting the height.
By adjusting the height,
yes.
Which is not.
Now, if you show that the height is more, then that will not come in aid of the candidate. Then height can be lowered down.
In my humble submission, Lordship, at the first instance, the height is 170, which is those who are eligible.
I'm not
at the,
that part is over. Now then come to a situation where a candidate's height is measured 170, say 171. So he has a
Lordship,
please hear me. Lordship. So that candidate has an excess height of 1 centimeter.
Lordship.
Don't
Lordship.
say no.
No,
excess height of 1 centimeter.
Lordship.
Now, if that candidate within the age group of 18 and 22 weighs 65 kg. Now, in order to bring down his weight within the parameters of 52 and 64, that is 64, higher limit, this height has to be lowered down. That can be lowered down to the extent of 0.5, to the extent of 0.5, 0.5. To the extent of 0.5?
To the extent of
because height is, because weight is higher side, weight is in the higher side. Yes. So in order to adjust, please, in order to adjust his weight, height has to be reduced. And according to you, that reduction is permissible to the extent of 0.5.
Lordship.
0.5. 0.5.
At that stage.
No, 0.5 it can be, yes, if I accept your submission, then this height can be lowered down to the extent of 0.5 at the time of medical test. At the time of medical test, as you are submitting, not physical standard test.
No, Lordship, if I just I am handing over a chart which I had.
No, you need not hand over the chart. You have already handed over a chart.
No. Lordship, what I'm trying to say is, in a hypothetical question, if he's overweight, now the 5 centimeter, if we put him into we relax his height, we add a height. We won't, because if it's reduced, the weight is going to go up. So if its height is increased by 0.5, then that ratio, he becomes eligible, he's put into that zone. It's the adding of the height, rounding off 2.5, not subtracting. So it's a adding of the height, which is done in case of when a candidate is overweight. We increase to keep the BMI within that zone, and thereafter, Lordship, weight can always be. He can check his weight. If he decides to go obese time to time, he will not be fit. But if the candidate is giving that much, we are allowing him to continue. He's passed all those stages. Now he's come to a stage where we find him overweight. There were no stipulations for weight at the initial screening. There is nothing that a candidate has to be 54 kgs or has to be that. No, that is flexible. Now we find a person who's overweight. Now, in order to keep him into that zone, it is we round off the height and then the ratio to bring him into the BMI zone. This is the calculation, Lordship. If your Lordships, I just got it because it is very confusing, Lordship. একটু দাঁড়ান, একটুখানি একটু আছে না বের কর দিয়ে দিচ্ছি नहीं 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 उस कॉपी को 171 का दिया था हाँ जस्ट मिनट এই কপি গুলো কোথাও জুনিয়র আর সিনিয়র জুনিয়র আজকে করতে চাই কোথায় গেল সব তো দেখো লর্ডশিপ ওনাদের কপিগুলো I had copies for them on the site. Junior हाँ ठीक है कोई बात नहीं these are all calculations. দিতে হবে আরেকটা করে কপি করিস তিনি আদার সাইড के लिए कॉपीज पारो you have to Lordship
Just a minute. Yes.
Lordship, this is it's another detailed more. I was looking for a more lucid calculation with my sense of maths, Lordship. But if this is it just this is a it's that only explained in a more lucid manner for me. Whether I've been able to put it across, I don't know. But which formula the one BMI ka formula? You have given me the BMI formula. ठीक है कोई बात नहीं height into squared height and weight divided by height squared like that is height in meters.
Age 22 years. What a picture. Yes. It's a no. Yes.
Copy को लोग उठाएगा अच्छा अच्छे गाना म्यूजिक करते हैं এটা
ये दे सकते हैं
इनको तो हम मेरा दे दीजिए तो मेरा दे दीजिए ये मेरे के लिए ये तो आप जो खुद को दिया ये है और एक फोटो देखिए देखो আরেকটা দিচ্ছি একটু কত
Yes.
क्या हुआ अच्छी
नहीं तुम्हारी 570 270 age 22 weight 78 without natural
So you are submitting that in order to adjust the weight, if a candidate is overweight, in that event, height has to be increased.
We can add it to the height to put him into the slot. If he's even more overweight, Lordship, then he is given time. The review medical examination is not held immediately. He is given an opportunity to cut down his weight. That is also done. So this is a weight can be adjusted. The height cannot. So if a person is even more than the slab, even adding the weight, rounding it off to 0.5, if he still remains overweight, Lordship, he is given the opportunity to come back after his weight is reduced. A particular time is given to him. Therefore, that is where, because at that stage, when a person reaches the medical stage, he's not to be, we have to keep him to the best of our ability. He'll be passing other tests, but it's not at the threshold, he's not being thrown out. That is my humble submission, Lordship. There is a decision of the division bench of the
Other matters are fixed on 18th.
I'll.
So let this matter appear. In the meantime, permit the petitioner to participate in the medical examination.
Okay.
Subject to final result of the.
Subject to final.
As I have passed orders in other matters.
Lordship.
You have to think over it.
Yes.
Yesterday, day before yesterday, I took a point that in terms of Rule 2D,
Yes.
Clause 2D, now it is stated that relaxation of 0. To the extent of 0.5 centimeter
Yes.
can be extended in favor of a candidate for rounding of his height to the next higher centimeter.
Absolutely.
Next higher centimeter. Next higher centimeter, meaning thereby if anybody's height is 169.5, it can be rounded up to 170. But it is submitted by Ms. Alam that while if this application is this relaxation is necessary only to adjust or only to consider or bring down the weight of a candidate if a candidate is found to be overweight. Now, in case of overweight cases or in overweight cases, suppose a candidate is weighing 1 kg more or 2 kg more, then lowering down height will not come in aid of that candidate because that will enhance his weight. That will enhance his weight. But if the height is enhanced,
then it can.
To the extent of 0.5, in that event, there is a scope of adjusting his weight to certain extent in order to show him that his weight is within the prescribed parameter. So according to them, there is no question of lowering down height. Always it has to be enhanced or increased to the extent of 0.5 so that height of the petitioner can be shown within the prescribed. Weight of the petitioner can be shown within the prescribed.
By respectful submission, my lord, then there would not have been any distinctive paragraphs stated for BMI is body mass index and the annexure shows the weight.
No. Annexure shows height in centimeters, age in years.
Required height.
BMI is a calculation that has to be arrived on the basis of that. And that's why, my lord.
That is the height, that is the age group. Age group, under the particular age group, what is the weight? What should be the appropriate weight? Considering the prescribed height or relevant height.
Anyway, my lord, let's come back on 11 and we'll.
Now, if you lower down the height, then his weight will enhance.
There is no scope of lowering down the height. No.
That's why I took this point under Rule 2D that if there is no scope of lowering down height. If there is no scope of lowering down height, then at the time of measuring, it has to be increased. At which level? At the level when this BMI is to be adjusted or weight is to be adjusted.
Anyway, my lord, we'll come back. But the fact remains is that if that is so, that the initial.
And already there is a judgment of the division bench of Madhya Pradesh High Court.
Yes, but
the issue is decided.
It's an issue is decided.
Anyway, we'll come back.
Anyway, let's come back. My lord, that is not in our respectful submission. It is not decided. Your lordship will, my lord, will.
I was wrong in considering that in order to adjust the weight, height cannot be lowered, since it is not contemplated under the relevant part of rule 2D. Now it is clarified to me that there is no question of lowering down height. For adjusting the weight, adjustment of weight comes when? But Miss Alam, if a candidate is below the prescribed weight, if weight of a candidate is below the prescribed level,
same thing, he gets time. Weight is something that can be adjusted. If he's -5, he gets that.
No, suppose
that ratio is there.
please think reverse.
I'll
Please
come back
think
to you.
reverse.
I'll come back to you.
No.
Also.
Please think reverse.
Yes, yes.
If 172 is the height, now you have given a chart, age 22 years,
requisite weight
73.
Yes.
And weight 73 kg, a candidate's height is recorded 174.5. Now age is 22 years. Now weight is 73. What is the maximum height? Suppose it's a case of, suppose in a case, a candidate's height is 172 centimeter.
Lordship.
Now the weight is 54 to 66. That is the prescribed weight.
If it's lower.
If it is lower.
If it is lower. Lordship.
Then you have to lower down the height.
Lordship will the height. Lordship will kindly see. Height is static. Height
no, you have.
Lordship will kindly see. A person has a height.
Is static.
It is static.
But in terms of 2D.
In terms of 2D, if I have to bring him into some position, I would either give him time to come back with a proper weight. I will not let him go. That is, Lordship, I shall.
Because you are showing the example of overweight cases.
Overweight. Even if he's under,
in the case that the petitioner is underweight
Lordship,
or candidate is underweight,
yes, Lordship,
then you have to give the relaxation to the extent of 0.5 centimeter.
Lordship,
and there is a requirement to reduce the height.
Lordship, the body
that is impermissible under 2D.
That
Yes, another respectful submission, 2D stand distinct. 2D clearly said it stands out of the medical. So, there cannot be any.
Lordship, 2D is part of the medical guidelines. It is not distinct. Prior to the medical.
No, it is stated nowhere. This is your submission.
No, it
is stated nowhere. Now, on the next date, we'll read
yes,
simultaneously. It is stated nowhere.
Lordship,
Now, your contention is this: always the height needs to be increased. But in case of underweight, in case of a candidate whose weight is below the prescribed underweight candidate, then you require to reduce the height.
Lordship, in my humble submission is
then that is not permissible under.
Lordship, under
2D.
My humble submission, Lordship, the height has to be 170, whatever the required height.
Height constant, but relaxation can be allowed.
At that level,
to the extent of 0.5.
Lordship, the relaxation cannot be allowed at that level. That Lordship will come.
You are giving the example which comes in your favor.
I have to think
in case of overweight.
I agree.
In case of Miss Alam, in case of
I should
think about yes, that's why I'm telling you.
No, it has to be both ways.
Think about underweight cases.
Yes, for a person who's gone through all the tests.
Then
but she's underweight.
Benefit,
what happens?
Then benefit of 2D has to be given in a fashion that this height has to be lowered down to the extent of 0.5.
Lordship, that I shall, Lordship, I shall come back.
Which
with that.
appears to be impermissible in terms of 2D.
I shall come back with that, Lordship.
Yes. Very well, come back 18th.
Yes, if your Lordship, in the meantime, allow us to.
The same order, give me another order, which I passed on the previous occasion.
6, 7, 8,
6, 7, 3rd December.
3rd December order.
এটা তো নিল না ওটা পাঠিয়ে দিয়েছে অর্ডারের কপিটা তাহলে আরেকটা কপি চাই তো এটা নাহলে কি করে হবে ও তো ডিফারেন্ট অফিসার আছে এটা শুভেন্দুকে পাঠিয়ে দাও নাহলে পারবে না করতে হবে
আবার দে না কেস না দিলে বুদ্ধি বাজিয়ে কি করে আরে এরাই তো এই কথাটা তোর মক্কেলের কথা তুই শুনি আমার টাইম আচ্ছা ঠিক আছে
Interesting point. Very interesting.
Very
point.
interesting, Lordship. So,
Whenever submissions are being made on behalf of elaborate submissions on behalf of respondents, I find that yes, there is a logic in it. But while thinking it, I find that there is other factors
no,
which
that,
are required
Lordship,
to be
that
taken
we
into
have to,
consideration.
that, Lordship, that is, and that we also will have to satisfy whatever your Lordship's queries are.
Yes, where is your height, measurement of height? Single petitioner.
Yes, single petitioner.
Where is the measure? 169.6.
Yes.
লিখে নিন এটা সিমিলার অর্ডার হবে এটা আইটেম নাম্বার 6 169 পয়েন্ট ম্যাটার ইজ হার্ড get benefit of election. It is in review or appeal. This height was measured.
Pursuant to the direction passed by this court.
It was treated as an appeal.
It
It was treated as an appeal.
Finally measured 169.6 height লিখে রাখুন 169.6 centimeter 169.6 centimeter 169.6
Yes.
centimeter which is less than 170
Page 33.
এটা 170 সেন্টিমিটার হবে ভুল আছে মিস আলম প্যারাগ্রাফ 8টা কাট হবে না প্যারাগ্রাফ 9টা হবে না 10টা আবার হবে সেম অর্ডার করুন শুধু হাইটটা চেঞ্জ হতে থাকবে ইয়েস নেক্সট প্লিজ কল দ্য নেক্সট ম্যাটার এটা নিয়ে নাও
Item number 7.
7
সেভেনটার নাম কি সেভেনের নাম কি
Page 23, my lord.
দেবদাস
Page 23, 169.7 is the height.
169.7 হাইট 169.7 সেন্টিমিটার কিন্তু হ্যাঁ
এটা নিয়ে নেবেন
সেম অর্ডার হবে আদারওয়াইজ মিস আলাম ইজ অ্যাপিয়ারিং
only yes
yes same order and the next one
Item number 8.
My lord, item number 8, your lordship will find it at page 22. 169.6.
you are appearing 169.6 সেন্টিমিটার
Affidavit of substance.
আর ওটা উপরে একটা দিয়ে দিন পেজ দিস ইজ আইটেম নাম্বার 8 affidavit of service filed on behalf of the petitioner is taken on record.
Great.
Miss Alam, you hold a further conference
Yes,
and demonstrate before this court that the cases which you have today placed before this court, that is in case of overweight. In case of underweight, what would be the adjustment of height in terms of
lordship.
So I am keeping this.
Yes.
এটা একটা আলাদা ফাইল করে দেবে তো হাইট বলে করে করে হেডিং করে এরকম একটা ফাইলের মধ্যে করে আমার এটার সঙ্গে পাঠাও বা আলাদা করে পাঠিয়ে দাও